President, Shri Sandeep Isore, to kindly come forward, and along with him, Senior Counsel and Advocate, Shri Sanjay Kadamji, kindly join us on stage, please. I will also request our immediate past President, Shri Manoj Kumar Dubal, to join us on stage, along with Advocate Shri Pradeep Gandhi. Shri Prasad Satyan to kindly join us on stage. Vice President, Engineer Shashikant Jadhav and Engineer Yomesh Rao, kindly join us on stage. Honorary Secretary, Architect Milind Changani and Joint Honorary Secretary, Suyog Sheth, please join us. And our event chairman, Architect Shirish Sukhadme, please. Even I will request the other speakers, Shri Abhiraj Girkar and Akshay Papale, to please join us on stage. I will now request our President, Shri Sandeep Isore, to felicitate Senior Advocate, Shri Sanjay Kadamji. Immediate past President, Shri Manoj Kumar Dubal, to felicitate Advocate Shri Pradeep Gandhi. Huge round of applause, please. Request our Vice President, Engineer Yomesh Rao, to felicitate Shri Prasad Satyan. We acknowledge the presence of Shri Chandrakant Undge sir, retired Chief Engineer Vigilance. Kindly join us on stage, sir. Vice President Shri Shashi Jadhav to felicitate Shri Undge sir. Our Honorary Secretary Shri Milind Changani, kindly felicitate Shri Avinash Tambewak sir. Sir, please join us on stage. Shri C.D. Chaudhary sir, retired Chief Engineer WSP. So, as professionals, we know the real complexity often begins when we ask the questions, what exactly has to be conveyed? And how do law and planning principles come together in determining the entitlement of individual societies in multi-building layouts? These are precisely the kind of questions that make today's subject truly techno-legal. We have excellent lineup of eminent professionals this evening, and I am sure today's deliberations will be intellectually stimulating and practically useful to each one of us. So, I would now request our President, Shri Sandeep Isore, to kindly deliver the welcome address. A huge round of applause for President Shri Sandeep Isore.
Good evening, everybody. So far as PIATA's known force is concerned, this particularly is a different kind of topic, which we were thinking of working on it for last almost 6 to 7 months, because there are so many court judgments on deemed conveyance, and if we meet 10 people, there are 10 different opinions on what deemed conveyance would mean. To start with, when MOFA came into existence and its rules and provisions came into force in 1963-64, probably the rule makers were not aware what kind of complexity this particular act will experience as the day progresses or the generations progresses. So mostly it was drafted or released for the people by considering a single plot having a single building. It was very simple arithmetic as well as simple logic to understand. Of course, down the line, even the simple logic was not implemented in the true spirit. Everybody knows that. And that's why one fine day in 2008, I think, Satyen may correct me, in 2008, deemed conveyance provision came into existence or operation. Because things were not getting conveyed in the true spirit or at the proper time. So then the second party or ex-party conveyance was made into force by the government in 2008. And today is 2026. So PIT is already led by a decade to discuss on this topic, but it is never too late. So we thought normally we are dealing with regulations, BMC Act, MRTP Act, licensing difficulties, the authorities, their way of implementation, their way of interpretation. But this is particularly a very different subject. When we thought MOFA Act, then there was a RERA Act. So what are the difference of enforcement of conveyance or deemed conveyance under these two separate acts? We were not knowing. Neither many of us are aware about that. So rather than making any guidelines or judgmental approach today, I think we as a committee decided to start the discussion on this topic. So as we keep on discussing, keep on interacting with those who are day in and day out experiencing this subject in the Honorable High Court. So thanks to both the practitioners that accepted our invitation at the very instance when Mr. Sukhatme as our convener has approached both of them. Thank you, sir. And that is what people are mostly thinking, that this particularly subject is going towards more of a legal approach, having some legal pronunciation and then to be executed in that particular fashion. But when we discuss this particular topic in our executive committee, myself and Mr. Girkar, who is a retired joint director from Town Planning Department, and we used to communicate with each other when he was in UD department. So we thought that let us try and study all these things so that to our fraternity as well as to common public or person, we may try someday to give clarity on this subject. But by the time we could give some clarity, even we were taken aghast by knowing that even provision in the MOFA Act and provision in the RERA Act on these particular aspects are to some extent different. And MOFA was more enforceable in the domain of general public. The same has now been amended in December 25. So what are those amendments? What are the difference of deemed conveyance aspects in both these acts, RERA Act and MOFA Act? What are the pronounced judgment and what does that mean today when we apply to a plot having a single building, when we apply for a layout having 10 buildings, or for example 100 acres of big layout which will go on for 10-20 years to complete. So how these particular provisions will suffice and get operated within that particular journey of that particular big projects. So all these are unknown things. So we thought that let us have a dialogue. We may not get a particular single point agenda, okay, yes, this will be like this. but at least we will all have certainly certain awareness about what are the judgments and whether judgments are also need some support regulatory aspect wise or some technical aspect wise. But that is to be discussed and get the knowledge about that. With this, I think I should thank first to all those who have come in such a torrential rain. Yesterday it was so nice weather. We never thought that tomorrow it will rain to that extent. And that is what probably is implying us how dim conveyance is otherwise a difficult subject. So with that, I throw open this particular topic for discussion, presentation. I only would like to tell the audience, whatever is being presented is a studied material, not the opinion of the one who is presenting that. Probably certain very firm opinions may be there from the both who are practicing in the High Court or other courts. But so far as PIATA's presenters are concerned, this is only an effort to collect the information and give it to put it forward to the audience to think about that. Thank you.
Thank you, sir, for your welcome note and setting the context for today's evening. So we would now come to the keynote address by Shri Abhiraj Girkar. So Abhiraj Girkar, sir, is a former Joint Director, Town Planning and Valuation and Metropolitan Planner with an impressive 36 years of experience in the public sector and in the field of urban planning. Over his extensive career, he has led and delivered planning concepts and policies across diverse and complex environments. Among his notable achievements is leading the preparation of the Pune Metropolitan Region Development Plan, covering approximately 7,000 square kilometers, as well as development plans of 8 other cities in Maharashtra. So I would now request Shri Abhiraj Girkar ji to deliver the keynote. A huge round of applause for.
Thank you, President Sir and Akshay. Honorable dignitaries, eminent speakers, senior officers of government and BMC, architects, engineers, all the respected members of PIATA, and the representative of the housing societies. Ladies and gentlemen, good evening to all. It gives me a pleasure to welcome all of you on this topic of dim conveyance. Firstly, I will say that I am deeply honored and privileged that our President and the Executive Committee has entrusted me with the responsibility to serve as the convener of this workshop. Thank you, President Sir. Today's topic, the issue, is not only regarding any documentation or conveyance, but it concerns with the thousands of housing societies and millions of flat owners who have invested their lifetime saving to purchase the flat, with the belief that they are believing that acquisition of the flat also includes land and buildings, lands and surrounding areas surrounding the building. Unfortunately, the experience has shown that this expectation has not always been fulfilled. Despite statutory obligations, many promoters are declined or refuse to execute the conveyance deed in favor of the housing societies. Therefore, the housing societies remain only the occupants of the building, but not the actual legal owner of the land and building. Recognizing this widespread injustice, the government of Maharashtra has introduced the concept of deemed conveyance in Maharashtra Ownership Flat Act 1963, that is MOFA Act. This provision enable the housing societies to get the conveyance of their land in spite of refusal of the developer to execute the conveyance deed. But still, many societies are not getting the conveyance due to many factors like title of the land, fragmented layouts, pending litigation, etc. Therefore, this conference is of immense importance. PIETA, as President said, PIETA has established this platform wherein authorities, legal experts, technical experts, architects can discuss, deliberate on various issues of legal and technical matter, and they will come up with certain solution that will benefit all the societies. This workshop will not be only related to the legal matters, but it will encompasses the technical matter. As you all know that this today's DCPR 2034 is a complex regulation compared to 1967 regulation and 1991 regulation. There are so many incentive FSI are there, so many permutation combinations of regulation, so it becomes more complex. All the architects know this. So therefore, like President Sir said, in a single building it is easy, but the layout where there are multiple buildings are there and where multiple numbers of regulations are used, the conveyance of the land to the society which are completed, if it is for total buildings, it may be easy. But when, because there are number of buildings and that project will go up to for number of years, so society will not wait. So we are transferring the land one by one, and therefore it is a very crucial stage. It is against this background that we must appreciate the significance of the MOFA Act. MOFA Act is not merely a regulatory statute. It is a beneficial social welfare legislation enacted to protect flat purchasers against exploitation and to ensure transparency, accountability, and fairness in real estate transaction. If we see the statutory scheme of the Act, it is clear that the theme is clear that the promoter is only the facilitator for development. Ownership of the land and building must ultimately vest in the society. I will like to present certain important provisions of this Act, which are beneficial to the people, to the flat owners. The first is Section 3. It imposes the complete disclosure, obligation regarding title, sanction plans, encumbrances, and approvals. So the developer or the promoter has to show all the details of the title of the land, sanction building plans, if any encumbrances are there, and approvals to the flat owners, flat purchaser, who will come to them to purchase the flat. So flat purchaser will able to know the detail of the scheme before taking any decision. Then Section 4, it mandates a written and registered agreement for sale. So that agreement, that also has a time limit. That agreement has to be done before 20% of the amount has to be given to the developer. So after that, it is a fault. It is a regulation fault. Then Section 10 requires the promoter to take steps to formation of the cooperative society or other legal body of purchaser within the prescribed period. That period is also fixed, that when the flat owners are able to form the society, so they have so much numbers of the flat owners that they can form the society, the developer has to form the society. Then Section 11. Section 11 imposes a statutory obligation upon the promoter to execute the conveyance of its right, title, and interest. This is very important. Right, title, and interest in the land and in the building in favor of society. So when he has to do it? So he has to do within 4 months from the formation of the society, or if there is any written time limit is there in the agreement, so he has to adhere to that time limit. So the Act provided all the facilities to the flat purchaser that they can first understand the project, they can form the society, when they have to form the agreement, and they have to get a land. But unfortunately, despite all these statutory obligations, many promoters fail to execute conveyance deed because there may be various reasons. I don't want to go exactly in all reasons, but the general reasons we can say are the residual FSI, TDR, redevelopment rights. So there are many ways that promoters don't want to go for the conveyance. So the government has understood this position, and in 2008, government has amended the MOFA Act. Section 11 was made more powerful. It was ensured that the statutory right of flat purchaser do not become illusory because a promoter refuses to execute the conveyance deed. So they have made the two main provisions. The first provision is that the government has appointed competent authority from the cooperative field, from the cooperative department of Government of Maharashtra. So if the promoter fails to execute conveyance deed, the society has to apply to the competent authority along with their registered documents. Register there, whatever the flat documents are there, they have to apply to that. They have to give the completion certificate. And they can request that competent authority for the deemed conveyance certificate. The competent authority thereafter verify the proposal. He will give the hearing to the promoter, and if he satisfies, then he will give the certificate. And now this society is eligible for the conveyance deed. When the society gets this certificate, they can apply to the registrar with the certificate and unilateral conveyance deed. Again, that registrar will give the hearing to the promoter. He will check with them. He will cause the show cause notice to the promoter. And after satisfaction of that, he will execute the unilateral conveyance deed in favor of the society. So the MOFA Act is more clear. All the provisions are with respect to the flat owners. Now, as I earlier said, the issue is regarding the mainly the layout wherein number of buildings are there. So government has issued one guidelines. It is not only for the layout, but for all the provisions of the MOFA Act. But basically, I'm proposing this as a layout, whatever the guidelines of layout, concerned with layout, so that I'm putting here. And this is very important. So what the first provision is that, it is dated 22nd June 2018. So what it says, if there are many buildings on one plot and have a separate cooperative society of each building, and if construction of some of them is incomplete, then while making deemed conveyance of the completed building, so whichever the building is completed, they can get the conveyance. But then how to do that conveyance? That is very important. So what the provision they had did is that, in that case, undivided share of occupancy right in the proportion of construction on the proportionate area of the construction of building of such society. So whatever the construction area is that, so proportionate of that construction, he can get the undivided share. Or, there is or are there, or ground coverage, or plinth area. So there are two options. Two options are given, either the proportionate share or the ground coverage or plinth area. Similarly, along with that, they will get the share of occupancy right in open space, common services and facilities, and road also. So this is the first provision. But now in the layout, where TDR is consumed, the government has come up with the second option. So in that case, it mentioned that while making a deemed conveyance in respect of the buildings in the layout where TDR is utilized, their conveyance should be made according to the plinth and appurtenant area. So that option of the proportionate built-up area has not been given in the cases where TDR has been used. This is the provision, what the guidelines of the government are there. So these all are the act provision, guidelines, and all these things are there. Now there are number of writ petitions, number of cases wherein honorable high courts have given their verdicts. Our eminent speakers, they will give more guide on that. But regarding this layout of two buildings or many buildings, so I came under the two writ petitions, the decision two writ petitions, and I want to like to share with you. Yeah. So first is the writ petition number 3530 of 2026. That is the Nilkanta mention versus Deputy Registrar Thane. So just the information for that, I just mentioned, the area of the plot is 56,607 square meter. Net area is 46,449. And the recreation area is 10%, that is a 4604. Then there are multiple type of buildings. There are row house buildings are there, high tower buildings are there. So the built-up area of the row house, that is R1 to R12, is 1640.40 square meter, that is 1.71%. And the built-up area of other buildings is 98.29%. So these row housing peoples, they went for the deemed conveyance. And the competent authority, based on the proportionate built-up area, had granted them the deemed conveyance of 788 square meter of land, that is 1.71% of the total land. And also they got the proportionate share in amenity space, that is 141.21 square meter. So against that, the petitioner developer, they contended, they have gone to the writ petition. They said, I have used the TDR at measuring 24950.45 square meter. And it is reflected in the architect's certificate also. So based on that, they said, कि now as per the GR dated 22nd June 2018, conveyance shall be granted only of plinth and appurtenant area. So their contention is based mainly on the government's guidelines dated 22nd January. Now the judgment, the Honorable High Court has given various issues. They mentioned that para 2C62 of GR means regarding that where the TDR is used and only where the plinth and appurtenant area is to be given. They mentioned that it makes a transitional arrangement to surmount the difficulty faced in land subdivision due to use of TDR. And it cannot be read to mean an absolute prohibition for application of land division proportionate to built-up area in every case. So what they said is that TDR has been used, okay, fine. But that TDR is not, if it is not used one by one, if it is in all the buildings, then there is no issue for granting the conveyance as per the proportionate built-up area. So in the second they mention that TDR is not, in this case, they mention TDR is not selectively loaded in a particular building. In this case, it was not loaded in a particular building, resulting in FSI imbalance for computation of land entitlement of each building. And therefore, there shall be no difficulty in following the principle of land division proportionate to built-up area envisaged in GR. They mention that if it is the position is like that, TDR is used on only certain buildings and not for another buildings, then there is a difficulty. But if TDR is used throughout all buildings, then there may not be issue of the proportionate built-up area. That is the Honorable High Court's verdict. And therefore, it says that CA has correctly divided the land. Next. Now I came across the second judgment. It is the writ petition number 10961 of 2025, judgment dated 28 April 2026. Rashesh Cooperative Housing Society versus State of Maharashtra, District Registrar and Developer. In this thing, what happened? The petitioner's building has a built-up area of 6888.6 square meter out of total built-up area of 34,459 square meter, which amounts to 19.99% of the total built-up area. And accordingly, they claim that the area liable to be conveyed in their favor aggregate to 3987.16 square meter together with the proportionate right in RG admeasuring 703 square meter. So they said ki whatever my built-up area is there, proportion built-up area, so accordingly I must get. The respondent contended that the apparent area must be such area upon which the building is dependent for its use, and it must be physically contiguous and adjoining to the land. So what the respondent says is that the apparent area should not be any area. It should be limited. It should be limited to whatever the requirement of that building, whatever the use of that building. So in the judgment, what the Honorable High Court said, where a building is conveyed to a society of flat purchaser, the transfer carries with it those surrounding lands and open spaces which are appurtenant necessary or incidental to the beneficial enjoyment of that building. So it must come out with the appurtenant land. Only building can't be conveyed. The appurtenant land must be there. But the court says the appurtenant land area is to be determined, there is no regulation, is to be determined by the DC regulation, approved plans and actual use. So it may be the required marginal distance or the proposed marginal distance, then you have to see as per the approved plans. Then in the certificate submitted by the petitioner, their what it is a court's wording. In the certificate submitted by petitioner, their proportionate share of net plot area based on the built-up area is 3987.16. That court has said, okay, fine. But it represents the proportionate entitlement in net plot area, not the covered ground area of the petitioner structure. So it's entitlement, but their actual area adjoining to their building might be less. So the court has given a verdict that the petitioner society is entitled to deem conveyance in accordance with section 11 and government resolution. And therefore court said that its plinth area is 1151.56 square meter, and appurtenant land which the architect has given, that area was 1050 square meter, and therefore they are entitled for the 2201 square meter land instead of earlier what he was defending for 3987. So here court has said that the society is entitled for the plinth area and the appurtenant area as per the GR. So these are the two verdicts. Eminent speakers can give more light on that. Okay. So now third. Yeah. So I got one architect certificate. So I taken as that as a case study for me. This is my case study. I can't say this is the what you just check on that and you can propose your say on that. So if you can see the map, see there are number one is a down building. Sorry, one number is a down there and one building is there. Then number two building consists of 3 wings. Number 3 building number 3 consists of 4 wings. And building number 4 consists of total 5 wings. The total area of the plot is 21,644 square meter. And after deducting all setback and everything, the net area is 16,000 square meter. Then by considering the road setback, the permissible FSI built-up area is 18,000. By taking the FSI credit by TDR of 4980, the total permissible built-up area is 22,995. Out of that, total built-up area consumed is 22,589.21 square meter. So this is the what sanction plan it is. Whatever the hatch that I have shown, it was not on the plan, but this I had drawn. I will show you why we are drawn. Next. Now we'll come to the architect certificate. What certificate they are given and how they arrive at the share of the plot. So what they have done is that they have taken the built-up area of each building. So building number 1 is 2451, 2 and 3 is 10061, 4 is 10,076. Now they came with the share of the built-up area. So building number 1, that is a 10.85 share. Building number 2 and 3, 44.54 share. And 4 is 44.61% share. So this is the share they calculated. Now, according to that share, they have conveyed the area. So area to be considered for conveyance, that is as per this share. The total area to be shared is 16,013. That is the 16,013 area. And then according to the share of the built-up area, they have conveyed the area to one number is 1738, 7132 and 7143. Likewise, they have given the undivided rights in the RG to each and every buildings. Again, undivided rights in road and undivided rights in TDR. This is what they have proposed in their certificate. Now, from my point of view, what are the issues in that? The first issue I can say is that the actual land under the plinth and appurtenant area are different. Just please go behind. See if you can see in the layout. The first point is that I can say that the 15% RG has been deducted, but physically 25% RG has been proposed. So on the land, the RG is 25%. And the architect has considered only 15% of the RG. Then by considering the RG and the internal roads, the area of their appurtenant land is much less. If you consider the proportionate land area as per the built-up area, that land, how we can define that land? Though we can calculate the land, but actually on the plan, how we can say this is the land? We can't able to see that one. Also, the land under internal approach road, they have not considered. So these are the points, lacunas, I can say. Maybe I will not say this is wrong, but these are my points. These are the difficulties when we go by the proportionate built-up area, because actual land may not be available. Only proportionate share. So you can say proportionate share is okay, fine, but you can't transfer any actual land to that society. So what I had done, now I had done my experience, what some proposal I have given. Let go. So this is the proposed conveyance from my side. So how I did that one, I will tell you. Again, I did the same thing first. That is the built-up area, the share of built-up area, that is 10 point whatever is there, same only I taken. Then, total land required to be conveyed and shared. It should not be, it should be given. That is as per the percentage of the built-up area. That I calculated. So according to the percentage, that comes, because total land to be given is 18,883. So I given as per the proportionate, that is 2049, 8410 and 8428. Then I calculate actually the plinth area and the appurtenant land area as per the actual map. Please go to map. See, whatever the plinth area and the appurtenant area, so that hatch I had done, and that area I calculated for every building. For building number 1, for 2, for 3, and for 4. So if you can see, though building number 1 has the less built-up area, their land is more. But building number 4, they have the more built-up area, but their land is less. This is the physical division. This is the, what you can say, undivided share. DIM, we can say. So I consider the plinth area and their appurtenant area. Now come to this one. Yeah. So the appurtenant area and the, plinth area and appurtenant area. So for one number is 2049, for 2 is 6661, 4359 and 13069. Now, see, building number 1 has more area within their kitty. So now when we do the share of the RG and the road area, they should get the less area. So what I did is that I deducted the total land required to be shared from that to the plinth area. So 209 already they got as a plinth and appurtenant area. They are entitled for 2049. So now they will not get any share in RG area. Likewise, for building number 2, 3, they will get the share of 6661, then 4359. So what my proposal is that now the share of the land is mostly now become the equal, because now they are getting the less in the RG area, but they got the more in the plinth and appurtenant area. Then thereafter, undivided rights in TDR and undivided rights in road is almost same. There is no difference of that. So as per my proposal, whatever they get is the plinth area and upland, that is this 13,069, and undivided right in RG and internal road, then TDR and the road. That is what I propose. I just request that if you can consider and you can comment on that whenever the question session starts. Fine. So, next. I am confident that today's deliberation will provide participants with a deeper understanding of the legal framework, recent judicial pronouncement, documentary requirement. But I think that this only one day workshop will not suffice. I think this will be the kickstart of the process. I will request our Honorable President that this process shall go on. Maybe that your architects may raise no question, but ultimately within certain time limit, they should give certain suggestions about this conveyance so that the executive committee will decide on that, will discuss, will check that whatever your suggestion will be there. And then they will submit, they prepare certain solution for that, certain guidelines, basically regarding the layout cases. And they may propose that guidelines to the government. I am sure that government will be more happy that they will see that societies, housing societies, will get a more justice for that. And they will get a right land. And maybe the writ petition also will get reduced. Before I conclude, I extend my sincere appreciation to the organizer, speakers, and every participant. I wish this workshop every success and look forward to fruitful deliberation that will benefit housing societies across the India and across the Maharashtra. Thank you. Jai Hind, Jai Maharashtra.
Thank you, sir, for the extremely insightful presentation and enlightening us with the provisions of the MOFA Act and their benefits for the housing societies. We even heard about the relationships of plinth area, appurtenant land, proportionate rights, RG, internal roads, and how can that affect the computation and allocation of land to the societies. The judgments referred were also not merely theoretical questions, but also they continue to be the live issues requiring more consideration by the professionals and the authorities. Thank you for giving such a in-depth presentation. Now, we come to the next presentation. This presentation is a joint presentation by practicing licensed surveyor, Shri Akshay Pafule and Shri Prasad Satyan for the legal perspectives in the presentation. Shri Satyan Prasad is a techno-legal consultant with over 21 years of professional expertise in the property planning and construction laws, with particular expertise in MRTP Act, DCPR 2034, municipal laws, MOFA, RERA, and deemed conveyance. What distinguishes his work is his extensive research database and his ability to simplify complex and legal and regulatory developments and translate them into practical implications for the professionals. Shri Akshay Papule is a civil engineer and has been practicing as licensed surveyor since 2021. And he has begun his professional career as a site engineer with the project of Prince Ali Khan Hospital. And now he has been doing his professional practice and is involved in the development and redevelopment projects across Mumbai city and suburbs. And I would now request both our speakers to kindly take the stage. A huge round of applause for both of them.
Good evening, everyone. So today's topic is deemed conveyance. So while preparing the presentation, we thought about the issues and requirement that will arise to define the criteria of deemed conveyance. But with the help and dedication of Prasad sir regarding the collection of various court orders and studying it, we were able to compile few judgments related to deemed conveyance. So we are presenting it that today. I would like to say thank you, Sir Girkar sir, as we have also taken same examples in our presentation, and you have explained it very beautifully. Please correct us if anything is wrong. Thank you. Next. So this is just a summary of our presentation. So these are 4 cases where Bombay High Court has already provided the judgments. First, case number 1, for a layout where part development is done by utilizing the zonal FSI and balance part development is done by utilizing the TDR. Case number 2, in a larger layout where part development is done by utilizing zonal FSI and part development is done by utilizing TDR, and that layout also consists the common RG or common amenities. Case number 3, in a layout where different FSI regimes are proposed for different buildings. Case number 4 is a layout where TDR, additional FSI, ancillary FSI is proposed across all the buildings available in the layout. And 5th one is the MOFA Amendment Act dated 31st December 2025. Next slide. Case number 1, Valentine Properties versus State of Maharashtra. In a multi-society layout where TDR has been utilized by some societies, the conveyable land area will be calculated based on the GR dated 22nd June 2018. As per clause B2 of the GR, the conveyable land area will be assessed as plinth plus appurtenant area, as Sir has already explained. And as per clause B3 of the GR, if the joint measurement of the layout is not done, then the competent authority must appoint an architect or LS for joint measurement, architect or LS from approved panel for measurement of the layout for all societies. Next. So next case is Rashesh Cooperative Housing Society versus State of Maharashtra. Similar case like case 1 with the common amenities and RG. In a multi-society layout where TDR has been utilized and layout also consists of RG or common amenities, the exclusive conveyance will be assessed as plinth plus appurtenant land, and the RG will be treated as proportionate undivided common right. Here we can see, next slide. Here we can see exclusive conveyance is actual plinth plus actual appurtenant area, and RG is proportionate common undivided right. Next slide. This is the actual calculation of Rashesh case, where Rajesh built-up area is 6,888.60 square meter. Total layout built-up area was 34,459 square meter, and net plot area was 19,949 square meter, and common amenities was 3,519 square meter. The plinth which was covered by Rashesh building was 1,151 square meter, and appurtenant area was 1,050 square meter. Therefore, exclusive conveyable area was 2,201, which is plinth plus appurtenant land. And for calculating the RG, we have calculated it based on proportionate area, based on utilized built-up area of that society. That is, built-up area of Rashesh divided by total layout built-up area multiplied with the common amenities or RG, that is 703. Therefore, the total for Rashesh is 2,905 square meter, but RG is not exclusive land. Next. So next case is Radha Vishweshwar Cooperative Housing Society versus New Bansi Park Cooperative Housing Society. It is a layout which is completed by utilizing FSI from different regime. Here we can see building number 1, which is Radha Vishweshwar Cooperative Housing Society, which was constructed by utilizing zonal FSI under DCR 1967, having total built-up area of 2,276 square meter. And building number 2, which is New Bansi Cooperative Housing Society, which is constructed by utilizing the TDR as per DCR 1991. The total built-up area for New Bansi was 4,535 square meter, which is including the TDR of 3463 square meter. Therefore, GR of 22nd June 2018 will not be applicable as layout was completed with different FSI regimes, multiple FSI regimes, 1967 and 1991. In this case, where one building was constructed with the base FSI and another is substantially constructed with outside TDR. In this scenario, court has decided to allow the redevelopment of building number 1, which is Radha Vishweshwar Cooperative Housing Society, with the land component of 2276 square meter, which is actual built-up area utilized by the society. It's an internal arrangement. The final judgment is yet to come. Next. Next is Nilkant Mansion versus District Deputy Registrar. It is a layout where TDR, additional FSI, ancillary FSI has been utilized across all societies which are present in the layout. Therefore, the conveyable land area will be measured based on proportionate built-up area basis. Next. This is actual calculation of the Nilkant Mansion Society, where built-up area utilized by Nilkant is 1640 square meter. Total layout built-up area was 95,785 square meter, and net plot area was 46049, and common amenities was 8245 square meter. Here we can see it is calculated on proportionate basis. Consumed built-up area of Nilkant Mansion divided by total layout built-up area. That is 1.71 proportionate percentage of entire layout. The net plot area multiplied by proportionate percentage, that is 787 square meter, and same is applicable for common amenities. Therefore, total conveyable area was 928.43 square meter for Nilkant Mansion Society. These were the judgments which were obtained prior to 31st December 2025. Here comes the MOFA Amendment Act. I would like to ask Prasad sir to take this. Thank you.
Yeah, hi, ladies and gentlemen. Today I will talk about MOFA Amendment Validation Act 2025. This act came into force on 31st December 2025. So now in this MOFA Validation Act, basically all the RERA projects, which is from 1st May 2016, if any deemed conveyance is pending, so all those deemed conveyance will be governed under the RERA Act, and there will be no MOFA provisions basically. Even the GR of 2018 would not be relevant at this point of time because the principal concept of proportionate concept has been removed in this MOFA Amendment and Validation Act. In MOFA, now in this RERA Act, basically now what they are saying is that conveyance will be given as per structure, conveyance will be given in a layout, and no proportionate land conveyance would be given. So in that way, what is going to happen if in a layout, if there are 10 buildings and say we have to wait till the 10th building to get the land conveyance basically. So there will be no proportionate land conveyance. There will be like no one or two societies can apply for joint deemed conveyance in this. So the principles of GR of 2018 cannot be used under this MOFA, under this RERA provisions. So anybody having, any societies who wants to have, deemed conveyance, they will have to apply to the competent authority only after that last building or the last wing of the layout is completed where OC is received. So maybe within 3 months you can apply for conveyance, and you can also form an apex federation, apex body or a federation. So once apex body and federation is there, the whole layout land would be conveyed to that particular apex body and federation. There will be no deemed conveyance to each society or maybe twin societies or maybe to a cluster societies. So new orders follow section 11A. The conveyance must mirror section 17. So under section 17 of RERA Act, we get the deemed conveyance basically. Read with Maharashtra RERA rules, that is 9. Next. So this is a common layout, basically no actual loss of FSI. So what the new regime protects is the aggregate layout FSI. No building-wise land is carved out before the last OC. Structure conveyance does not divide or extinguish the layout land. The total sanctioned development potential remains with the common layout. Hello. So the total sanctioned development potential remains with the common layout. After the last OC, the land and its FSI pass collectively to the layout body. What still needs governance is building-wise. The issue is allocation, not loss of FSI. No society receives separate frozen land, just like what used to happen in MOFA Act or any independent FSI bank. Redevelopment must be coordinated through the apex body federation because they are having the land share and the layout FSI. So after the last OC, the land and its FSI pass collectively to the layout body. So in fresh Section 11 cases, the fear of actual layout FSI loss is substantially neutralized. Next. So practical redevelopment effect after 31st December 2025. Structure first, land later. So until the last OC, structure conveyance only. No proportionate land or FSI is removed from the common pool. The last OC triggers conveyance of the entire inseparable layout. Within 3 months, conveyance is to be given to the apex body federation or jointly to the layout entities as applicable. So the practical consequences in collective redevelopment, societies retain collective undivided interest in the layout and FSI. Independent redevelopment requires layout level coordination and sanction plan. Any disputes concerning allocation or management, not depletion of total layout FSI. The total layout FSI remains intact, only its building-wise use becomes collectively governed. Next.
Thank you, Akshay, for the insights and all sorts of examples with permutation combinations and the detailed working as to how the proportionate land area has been worked out in each cases and as per the relevant court orders. And thank you, Satyan Prasad, for enlightening us with the updated MOFA Amendment and Validation Act and its impacts and implications in the present day scenario for the upcoming recent cases. So now we move forward to one of the main highlights of today's evening, the release of updated DCPR 2034, updated up to 30th June 2026. So as we are all aware that new notifications are issued from time to time by the UD department, and it is difficult to keep pace with all such amendments coming time to time. PIETA has compiled all the recent notifications, and hence here we are with the updated DCPR up to 30th June 2026. So the book has been launched yesterday with the hands of Honorable Municipal Commissioner Srimati Ashwini Pide. And I would now request all the dignitaries to please join us on stage for the launch of the book. All the dignitaries, please join us on stage. Yeah. And I would request Shri Vishal Thakkar from Naredco and representative from MCHI and BDA to also join us on stage. Yeah. So huge round of applause for all the dignitaries, and now we would be seeing the release of the new book. So everyone please join in congratulating Pieta and sir, please come on stage. Anybody from BDF? Please join in congratulating Pieta and the entire team involved in updating this new book. Update till 30th June 2026. Jadhav, please come on stage. Books are available for sale at the registration counters. Yeah. So thank you very much everyone. I would now request everyone to
I would request Ninad to remain on the stage because it is a Herculean task to compile and try to be correct on each and every page with all the corrections incorporated in different colors, serial numbers, index, all those things. And more than 80% responsibility was taken up by Ninad proactively. So now we are very sure that next editions will be implemented very successfully because such a young generation is now involved. So I would request Akshat Dubal, Akshay Papade and other young team to come forward along with Ninad in the next edition. It's a token of appreciation for Ninad so that others will feel to come forward. So I request Sukatme Sahib, आहेत का तुमच्या सिनियर मोस्ट माणसाच्या हातून त्याला आपण फेलिसिटेट करूया. I thank MCHI, I thank Naredeco, and a lot of thanks to BDA also. Has always been a support partner for Pieta. And I mean, I had taken liberty that whether you say yes or no, you will always be our support partners. And that message was given that we have already printed your name as a support partner on the new book. The Herculean task could be completed because of entire executive committee, I would say, but prominently Manoj Dubal sir and Shashi Jadhav, apart from Nikhil. Of course, president को तो कुछ ना कुछ काम करना ही है, तो एक ताली मेरे लिए भी बजा दो. And in his absence, the entire credit of this particular specified skillful job goes to Gopal Chiplonkar. I mean, it was his first concept. He made that particular first copy, maybe this year 1991 in some year, because till 2008 we both were in BMC. Once coming out of BMC, he took the initiative. He used his experience in BMC, and then it was replicated successfully by others also. But then pioneer needs to be given due respect. So a big round of applause for Engineer Gopal Chiplonkar. So fortunately this is videographed, so we will send him to wherever he is now in USA. Thank you. Akshat, mic is yours.
Thank you, sir, for the release of the book and encouraging us. We would definitely take due support and due help in the next amendments or the next updates whenever published. So now we move forward to our next presentation. The next presentation is by our Joint Honorary Secretary, Engineer Suyog Sheth, a practicing licensed surveyor, and he is a civil engineer from NIT Kurukshetra with a postgraduate degree in environmental engineering from VJTI. He is practicing since last 20 years and is the Joint Honorary Secretary for PIETA also. I am sure that the practical perspective of a practicing professional will help us further understand the ground realities involved in such matters. Shri Suyog Sheth, a huge round of applause, please.
Good evening, everybody. President, learned friends in front of me. I am not going to refer to any legal precedents, nothing in terms of law, because there are enough friends here who would speak on them. We have senior advocates who would be speaking on this. I am focusing on a totally different aspect. We may have a lot of knowledge about the precedents in law, about the government directives. What do I do if somebody comes to me in my practice that please give me a certificate for deemed conveyance? What do I do? That is the key aspect today, right? Because we are all professionals. We all look at that scenario when somebody comes to me and requests me for a certificate. What is that I'm supposed to do? So I am focusing today only on the practical aspects. See, basically why the deemed conveyance started, it has got root in Mahabharata. See, why did Mahabharata start? Pandavas said, हमको कुछ जमीन दे दो. उन्होंने बोला सुई के नोक पे बैठे कि उतनी भी जमीन नहीं मिलेगी. महाभारत हो गया. Right? Same thing here. Large plot of land, more than one society. The GR also says that. Next, please. GR also says that when there is more than one society on a plot of land, one society has applied for deemed conveyance, other says we don't cooperate. So Mahabharata starts, and then you need Shri Krishna to give Gita Gyan, right? So we here as professionals are that Shri Krishna who's giving the Gita Gyan. So once we have that concept clear in my mind that I am here not to fight. I am here not to fight. Shri Krishna never fought in entire Mahabharata. He only advised of what is right, what is wrong, what is dharma, what is adharma. So our role is of Shri Krishna here in the entire deemed conveyance matter. Once we have that clear in our mind, lot of questions get answered automatically. If you read the GR literally, what does it say? What is the responsibility given to us? I am going to talk about the FSI, proportionate share and all that. Does the GR ask us to do that? No. GR says when there is a dispute, other societies do not cooperate, a professional will go to site, measure the plot and give a report, period. So the guidelines do not want us to do all that calculations. Why do we do it? There is an implication. Next, if you see in the para 2D1, where it is said that when it goes to adjudication before the collector, that time collector will see that the professional has certified that there is no FSI balance to be consumed. That means somewhere it is presumed that we have to calculate the FSI. That's why we do all this. See, it's very simple. DCR, if you read plain literal meaning of DCR, is very simple. But we like complexities. Because those complexities is what gives us our bread and butter, right? सिंपल होता, सबको समझ में आता तो कोई अपने पास आता ही नहीं. हम कॉम्प्लिकेटेड बनाते हैं और उसमें से हमारा गुजारा करते हैं. So that's what we do. But on a lighter note, but we really throw a lot of light on different aspects of the regulation and law and practice and all that. But so this, if you read at the GR, again, if we look at this GR, what is the genesis of this GR? This flows from MOFA Act. MOFA Act specified that within 4 months of occupation, you are supposed to give conveyance. Somebody has failed to follow the law. So government said deem conveyance. So genesis is in MOFA Act. Even RERA, what does RERA say? I have to declare. The consumer has to be aware. So if there is a layout which is continuing for last 20 years, few buildings have been constructed, few more I am constructing out of balanced TDR, then I am supposed to declare that yes, this was a building constructed in maybe 78 by me, first building. Next building constructed maybe in 89. The next after that 95. So when I buy a flat in the last building, I am aware that first building was constructed at that point of time, he should have given conveyance. So I should be asking a question, why did you didn't give conveyance? If you would have given within 4 months of the occupation, what that society would have got? What that society would have got? So if I answer all these questions, then automatically the rights of all the societies will follow through. Next, please. So in this background now, let us look at various scenarios. See, there is one scenario where there was no TDR. I'm talking about prior to 1991, no TDR. In fact, even the layout roads FSI was not granted. RG was not there till 2018. So 15% RG FSI was not available till 2018. So this is that case where plot area is 10,000, say internal roads of 2,000, ROS 1,500. So the plot, actually buildable plot is 6,500. So anybody will get a share of 6,500. The first building, which has come for deem conveyance, got a built-up area of 1,000 square meters. Then definitely, because, see again, I'll qualify this. This is for a suburb plot which has got 1 FSI. Even in suburb, there were certain plots which had only 0.5 FSI in 67 DCR. Some had 0.75. Some had even FSI of 4 in 67 DCR. So we talk about excess FSI now. अरे 4 का FSI, बारिश हो रही है FSI की. 67 में भी 4 का FSI था कुछ plots के लिए. So this is a plot in suburbs with 1 FSI. So with this in mind, if the area of the building was 1,000, then equivalent plot area is 1,000. Again, when we give a certificate about the share of a particular building in the layout, we have to first look at, and first question to be asked is the layout approved? If the layout and subdivision is approved, then whatever is the plot area on which the building stands, the area of that as per the approved subdivision is the area of that, is the share of that building in that larger plot. Because when the subdivision was approved, everybody realized that this plot is reserved for that particular society. Every other society accepted. So definitely if there is a subdivision, definitely subdivision takes precedence. If there is no subdivision, then equivalent built-up area can be worked out. Now in our report, there are a few things which we definitely have to mention. Share in common RG and layout road. That we have to mention. Then, interesting case is if we saw earlier speakers speaking about the plinth and appurtenant area. It may so happen that plinth and appurtenant area is much larger than the share of that particular building. Say a row house, there is a large number of row houses and only one tall building coming up. If I take the appurtenant area of that row house, it will be maybe even 80% of the plot. Possible. So, issue is rather than taking a view whether this judgment is correct or that judgment is correct, we can simply mention in our report that as per the proportionate philosophy of proportionality, this is the right. As per the appurtenant area and the plinth area, this is the society's share. Let the registrar decide. Here, we have to be very clear in our mind that we are nobody to decide what is the share of any particular society in the larger plot. We are only giving opinion. Who's the deciding authority here? The competent authority, Deputy Registrar of Societies. He is not only based on our opinion. My opinion is one of the facts that he is going to consider. There will be lawyers representing both the parties who will make their submissions. They will produce a lot of legal documents. सर वो टाइम पे वो जब मैंने कन्वेंस किया था प्लॉट का तो प्लॉट में लिखा था आपको इतना ही प्लॉट मिलेगा, आपको इसका राइट नहीं मिलेगा, आपको रोड का राइट नहीं मिलेगा. All that is for the lawyers to argue. All that is for the registrar to, deputy registrar to appreciate. We are here only to show the mirror as far as the regulations are concerned. That is what I feel. That is what we as professionals, if we restrict ourselves to this, will have less problems going forward. Again, it so happened that TDR was not there, but after 1991, before the TDR formally came in, there was a period when the layout road FSI was allowed. And it has so happened that in various layouts, pro rata share of the layout FSI was granted to individual plots. In such a case, again the same thing, the equivalent plot area comes down. Earlier it was 1000, it has come down to 764.71. Remaining qualifications remain. If there is a subdivision, you have to consider the subdivision. In the report, we have to mention the share in common RG. Here, see, share in road is already granted to everybody in terms of FSI. But now share in common RG is going to remain. Because now, in today's DCR, see, what I always request all of us is that let us look at not only today's DCPR, but also let's go back in time when that building got occupation. The building which is asking for team conveyance, when it got occupation, what was the regulation? What were the prevailing norms at that point of time? So if we have the total gamut in front of us, what happened then and what is possible now, then we would be better placed to give our report. Next, please. Now there is 1991 TDR came in, so there is a possibility that building constructed with TDR. Again, TDR, we all think that TDR was 1+1 in suburbs, right? It was not so. Initially it was 40%, restricted to 40%, then it increased to 80, then slum TDR came in, it increased to 100. On the day of occupation, what was the percentage of TDR? That we should look at. So, say here, entire slum TDR and everything had come in. Suppose that is the case, then what happened? 10,000 plot area, RG FSI was not allowed, 8,500. TDR, entire 10,000 TDR was permissible at that point of time. So it came to 18,500 total permissible built-up area. Again, pro rata share of that 8,500 comes to 918.92. Again, there is a share in common RG, that is what we have to mention, and we have to work out the plinth and appurtenant area. Next, please. We also have to look at buildings, not that buildings were only constructed with plot potential and plot potential plus TDR. There are buildings which are constructed under various special regulations, especially after 1991 DCR came into effect. So what are that? Next, please. Say CES building redeveloped. There are CES buildings which are redeveloped where there is rehab building, where there is sale building, and now they are coming up for redevelopment because some buildings are more than 30 years old. And looking at the kind of FSI that is available as per today's DCPR, they also are rushing in for redevelopment. So when such a building comes for redevelopment, then it is not simpliciter that plinth and appurtenant area can be worked out. we have to look at the potential. So if the rehab plot, say, if it is subdivided, say the rehab plot is 4,000, sale plot is 5,000, then definitely the rehab building will get conveyance of 4,000 and the other one 5,000. Here again we have to look at one more thing is, the FSI was on gross plot, not on net plot. Even today it is on gross plot, not on net plot. So that, because what share of a plot will go is from net plot, but FSI is on gross plot. So that is something that we have to appreciate and consider. Now, now what I am saying is, suppose there is no subdivision. There is a rehab building, there is a sale building, there is no subdivision. Then let us work out the plinth and appurtenant area of each building separately. And there will be some extra area. After the plinth and appurtenant area, when we say appurtenant area is the minimum open space that was required as per that regulation. So as per 1991 DCA, 1.5 was sufficient for certain height of building. So that much open space and appurtenant. So suppose in a plot of this, in this particular case, the plot is 10,000, 1,000 has gone in setback, remaining 9,000, out of which the plinth and appurtenant area of both the buildings together is 6,500. What remains is 2,500. This is the cookie that needs to crumble. 2,500 is something that needs to be distributed. So that I feel should be distributed in proportion to the built-up area. So that's how it has been worked out. So in terms of, because see, if the built-up area of rehab is 14,000, sale is 11,000, so total built-up area is 25,000. So if we divide the built-up area of that particular building with the total built-up area, that should be the logical share of both the buildings in that extra area, common area. That's how we can draw a dividing line and suggest. Next, please. 33.5 has come in 1991 DCR. Certain buildings have been developed. Some buildings are more than 20 years old now. Maybe more than 25 years old also. Now those buildings, when they come up for deemed conveyance, and there are more than one building, one rehab, one sale, large plot, they will come up for redevelopment. Same logic here. Say plot conveyed by MADA is 14,000. There is a rehab built-up area, there is sale built-up area. So each of them will get plot in proportion to the built-up area. So 15,000 is the rehab plot area, so they will get 6250. Sale plot area, they will get 7750. That's how we can make a statement that that's how the plot will get divided. Let us bear in mind that in some cases MADA has also conveyed the layout RG to that particular plot. But that layout RG is devoid of any FSI. And that layout RG is not the RG of that particular plot. That is the layout RG for the entire layout. So in this case, there cannot be any share in the layout RG, even though it falls within your layout. But that is to be enjoyed by every person who's staying in the larger layout, not on that particular plot. So there is no share of RG here for individual building. Now, slum redevelopment schemes. They are in vogue till 1989, when SRD fund started. Then SRA started in 1998. So those buildings, some of the initial buildings also are now up for redevelopment. They also can come up for conveyance. So in this case also, similar as in 33.5, the pro rata share of plot. Here also we have to bear in mind that the FSI is on gross plot. So the plot which can be actually apportioned to both will be lesser than the plot which derived FSI. And in SRA, the layout RG 8% which is given doesn't carry any FSI. Even today it doesn't carry, so even if the building go for redevelopment, there is no FSI for the layout RG. So there is no point in saying that you have got so much proportion in layout RG and you have got so much proportionate share in the layout RG. As compared to the TDR plots, where 15% RG was deducted as then, today that RG also carries FSI. But here there is no FSI for the 8% RG which was given. 8% or more, 8% is the bare minimum in slum schemes. Now I come to the, I would say, important portions as to what we should and we should not do. When we are giving these certificates, there are certain mistakes that many of us do, which we should avoid, and there are certain things which we should definitely keep in our mind. So for that, I would revert to Marathi here. आत्ताच एकादशी होऊन गेली, बरेच जण अजूनही हरिपाठ आपण वाचतो, चातुर्मास आहे. तर एक तुकाराम महाराजांचा म्हणून एक अभंग म्हटला जातो, त्यातले काही चरण मी सांगणार आहे. घासावा शब्द, तासावा शब्द, तोलावा शब्द बोलण्यापूर्वी. शब्द हेच कातर, शब्द सुई दोरा, बेतावा शब्द शास्त्राधारे. आपल्याकरता व्हॉट इज शास्त्र फॉर अस? DCPR, the regulations, the law. So whatever we say, whatever the words we use in our report should be measured, number one, and should have the basis, logic of regulations. If that we are following, we'll not fall short of our professional duties. See, the guidelines mandate that we measure the plot. So we should definitely visit the site, familiarize ourselves with the site. See, it's very tempting when somebody comes for advice, look at the layout, look at the approved plans, look at the OC plans. I have everything in front of me. Why should I visit the site? But it should, see, if we don't visit the site is on hill slope. I say so much is the plot which this society should get. Some of that may be unbuildable. Some of that may be on the hill slope. So unless and until we visit the site, this will not be clear. Collect all the relevant information, layout plan, OCC plan, property card of the larger plot. Study all this in addition to the applicable regulations. From at that point of time on the date of OC till today, what are the applicable regulations? Then we have clearer picture in our mind when we give an opinion. So these are the do's, then we come to don'ts. Don't be a part of the dispute. See, there is a dispute. हम श्री कृष्ण है, हम ना कौरव है ना पांडव है, हमें लड़ना नहीं है. Give advice, remain detached. See, it is very tempting when one society comes to me, I have to give advice because that society wants to take my certificate and rush to the deputy registrar. I am tempted to take the side of my client. There's a temptation. But here, yes, the client has come to me. The client is paying me my fees, but I have to stick to my professionalism. So if I do that, I'm being true to my profession. Never abandon professionalism under pressure or favor. See, most of the senior people who are here, who are practicing, they do not indulge into giving such certificates. Many a times we have to give such certificates because somebody requests us or we have to oblige somebody. But even if I am giving a certificate under obligation to somebody or because doing a favor to somebody, not that every time we do it for fees. Many times we have to do it as a part of larger practice. But that point of time, professionalism is supreme. I should never abandon my professionalism even when I am doing a favor to somebody or even when I am pressurized. And we are not deciding who's getting what area. We are not arbiter of the plot area. Who's deciding? Deputy registrar. वो बैठा है, ऊपर बैठा है, वो हिसाब करेगा. हम कोई हिसाब करने वाले नहीं है. So let deputy registrar decide. See, there will be legal covenants, legal documents, agreements, so many things will be produced. Why we should refer to that? Are we asked to refer to that by the law, by the GR? GR doesn't expect us to do that. GR expects the deputy registrar to do that. So let us leave it to deputy registrar. He will seek help from the competent lawyers of both the parties, by reading the data which is produced by both the parties, and give a final decision. We are not decision makers. See, many a times, even during discussions, we get animated when we talk about deemed conveyance. And we say, नहीं, ये तो गलत है, वो गलत है. कुछ गलत नहीं है. मेरा opinion सही होना चाहिए. मुझे, if I am giving an opinion, I should be satisfied with my opinion. It is true to my belief and knowledge. That is all that is required of us. Nothing beyond and nothing more. Thank you.
Thank you, sir, for enlightening us with the roles and responsibilities of the professionals and certain things that we should always keep in mind while preparing and giving such reports to any of our clients. I would now like to request Shri Suresh Babu from Institution of Engineers, India. He is the convener of the National Convention of the Institution of Engineers that is going to happen in Mumbai in September 2026. And he is here to say a few words about the event. A huge round of applause for him.
Good evening. Thank you, Honorable President and other office bearers and all my friends here. And I think PIATA is doing wonderful job, like, educating us, conducting this kind of a seminar. It will be really useful for fellow professionals and all the friends. Now, today I am going to just take 2 minutes before you continue with the other things. Now, in association with the PIATA, the Institution of Engineers India, Maharashtra State Center, under the aegis of Architectural Engineering Division Board, is conducting a national convention, 2-day national convention in Mumbai, that is Nehru Center, Worli, on September 12th and 13th. The theme of the convention is reimagining urban India, because we are all working for improving the life in city, improving the housing, infrastructure and other things. That is why we have taken the theme as reimagining urban India, pathways to livable city. Because we are all working and the government is putting so much of money, so much of effort to doing so many infrastructure projects, and investment is coming so big. But irrespective of that, our cities are, I don't know how much livable. Everywhere we go, traffic jam, pollution, diseases, lot of problems within the city, last mile connectivity, and how we can solve a little bit of this problem. Under the Institution of Engineers, we are bringing leading architects, leading town planners, urban designers, engineers under one roof. All the experts throughout India, and a few people are even from abroad, coming together and discussing what are the problems, how we can sort out, how can we make our cities more livable. Our government of India aim is to make India as a developed country by 2047. Unless our cities are livable, how can we make our country as a livable Vikasit Bharat? First, we have to make our cities livable. For that purpose, we are conducting this seminar. I request each one of you to attend that seminar. It will be something really, really nice. I really thank President and all of you for giving me this chance. I am leaving the brochure with the President, and they will be, in fact, giving further information in the WhatsApp group or your other medium of communication. And I expect all of you to participate in that. And thank you very much.
Thank you, sir, for inviting PIATA and all the members of PIATA for the National Convention. Now we would move towards the legal perspective of the today's techno-legal session. It is my privilege to introduce Advocate Pradeep Gandhi, a third-generation lawyer with 29 years of practice at the bar. His practice encompasses real estate and redevelopment matters, development agreements, housing society matters, municipal issues, litigations, conveyances, and legal opinions, along with other extensive practice. Given today's focus on deemed conveyance and its techno-legal implications, his experience in real estate and redevelopment law makes his perspective particularly valuable. Sir, please join us on stage. A huge round of applause for Advocate Pradeep Gandhi.
Good evening, friends. Good evening, the committee members who have been kind enough to invite me for this session. Being a lawyer in this profession, obviously, I may not be able to assist you on the technicalities with regard to plots, but from my legal perspective, I will like to share my experiences and issues with regard to deemed conveyance. The topic today is deemed conveyance, so, and appreciate the previous speakers who have already, in fact, explained a lot of things, so I don't want to repeat the same thing. So let us start with, I think I've just prepared a PowerPoint presentation, if someone can just. So the first, I don't need to repeat the same thing, but I'll just in a gist explain to you, which has already been explained by the previous speakers. The MOFA, which came into force in 1963, originally the whole objective of framing the MOFA was to ensure that the flat purchasers get their rightful dues. They should not be cheated by the builders, and in the end, after completion of the building and formation of society, be given conveyance. Now, unfortunately, in those days, conveyances were not being granted, and parties, if a society is formed, builders were not granting conveyance at that time. At that time, the situation was that if they want to go for a conveyance, they had to file a civil suit. And I don't need to explain to you, in civil suits, take decades to reach its final conclusion for grant of a conveyance. So an average life of a suit in Mumbai, because of pendency of so many matters, is almost 10 years. So I myself must have conducted so many trials and gone through so many matters prior to 2008, where conveyances have been, orders have been taken by me from a normal civil court. So keeping this aspect in mind, because of the gross delay in grant of a conveyance and the number of matters which keep on coming, and the development of Mumbai, which has just gone crazy from 1990 onwards, where more than 28,000 buildings are even today have not got conveyance. The government brought in this legislation in the year 2008, which is called deemed conveyance, by amending the MOFA Act and incorporating Section 11A in the Act, just to ensure that the societies do not need to go to civil courts and waste their time for a decade for grant of a conveyance, for which they started something called a tribunal, which is the DDR, the District Deputy Registrar, who has been given powers to grant a conveyance, and certain procedures are required to be followed, I think, which have already been explained by the previous speakers. I don't desire to repeat it again and again. So once this District Deputy Registrar has been envisaged with these powers, his job is to ensure that he gives notice to both the parties, that is the owner and the developer, and after hearing them, he is required to grant conveyance. We keep on coming across various such situations, and I'll just explain to you some of them. Now let's go to the first presentation. The District Deputy Registrar is required to grant conveyance, but there are so many instances which are very peculiar depending on the facts of every land, every property, every society has its own set of problems. The common problems which I am facing, and I'll share it with you. The first problem is leasehold rights. Many a times we come across a situation where a property, the original owner does not want to divest his ownership rights. So what he does is, in a larger plot of land, he says, I'll do one thing, I'll enter into a lease agreement with a developer and tell the developer to develop some portion of the land where he must have got FSI at that time, maybe in 60s, 70s, or as per DCR 1967 or 1991. And the remaining portion he keeps it for himself by making a small bungalow for himself as per mutual understanding with the developer. In such a situation, what happens is the whole issue here arises is leasehold rights. So there is a lease deed which has been executed somewhere in the 80s, 90s in the old buildings which have been made. And after the building has been constructed, the leasehold rights are given to the society, and society is the lessee. In such a situation, many a times situation arises where society goes in for conveyance, and whether such a conveyance can be granted by DDR has been determined by various judgments of Bombay High Court, which says that leasehold rights can only be assignment of leasehold rights. Ownership rights cannot be divested. So many such situations have arisen. One such situation is, I think, one such situation here is is what we call as, the leasehold rights are in one matter about Girnar Cooperative Housing Society versus State of Maharashtra, where a unilateral deemed conveyance was granted by the DDR without keeping in mind the leasehold rights which were already inside the property. Such a matter came up before Bombay High Court, and the Bombay High Court was very, very clear saying, sorry, this order is wrong, it has to be set aside. It can be assignment of leasehold rights, it can't be divesting of ownership rights. So the owner remains the same owner, because the person, because at that time in 1980s already a lease agreement was executed and they are bound by it. So in continuation with those leasehold rights, it can be only assignment of leasehold rights. A question may arise amongst all of you as to if there is an assignment of leasehold rights, what about the TDR and the FSI benefits? Answer to that is also very simple, by virtue of a Bombay High Court judgment which says if there is an assignment of leasehold rights, they can be given benefits of FSI and TDR only for that portion of it and not more than that. And those are in fact mentioned in various judgments, namely Prestige Garden Cooperative Housing Society versus State of Maharashtra, and various other judgments which are there. Girnar Santa Cruz Society also. Now this is one issue about leasehold rights. Then we come across various other issues which have already been explained with regard to proportionate share as per the 2018 GR. I do not desire to repeat the same thing. As rightly said by the previous speakers, those same judgments are absolutely applicable. But in major issues about layouts, there's problems keep on occurring time and again. For example, if it's a large layout land and there are not more than 10 to 12 buildings made, what happens is every building would like to go for a deemed conveyance. Now, if they go for a deemed conveyance, they can be given only deemed conveyance for their portion, supporting with the plinth area as explained under the 2018 GR. But they have to be given proportionate share in the RG as well as the roads which are there to it. And one more addition to it which I would like to add is, if it's a larger layout, it would be always advisable to form something called a federation, which will be the owner of the whole land and the common RGs and the common roads which are there, as well as the societies which have been formed on the smaller plots, they become owners of those plots of land. And the societies become members of that federation. So the parent organization is the federation and the societies become a part of that federation. And the federation will be in charge of maintaining the RGs, the roads and the common layouts and the common areas, which are very, very important. There are various judgments to that effect, and by Bombay High Court time and again they have been repeatedly said. I do not want to consume time on this issue, so please bear with me. I am aware that there are constraints of time. There are lots of other speakers also who are required to give their speech. Therefore, I am confining my arguments to that. Another situation which has arisen is with regard to jurisdictional limits of a competent authority. Like for example, there are many a times an issue arises where a DDR passes an order with regard to a dispute between the original owner and the builder, and the society wants to go in for a deemed conveyance. And if the DDR passes an order, such a matter which are tested in the Bombay High Court, repeatedly the Honorable High Court has said, if it's a mixed questions of facts and law, a writ petition is not maintainable. Normally, in all the orders passed by DDR, people try to go and approach directly the Bombay High Court exercising writ jurisdiction. Now, writ jurisdiction means an order passed by a competent authority or any governmental organization which can be dealing with only with issues of law. The moment an issue of fact and law arises, the Honorable High Court in its own wisdom says, writ jurisdiction is not maintainable. You should not come to a writ court. Please go and file a civil suit. And there are umpteen number of judgments on that point. The landmark judgment is Mazda Leasing, which is a very landmark judgment which explains that if there is a mixed question of facts and law, then such type of matters would always be relegated to a civil suit, and the Honorable High Courts in its own wisdom grant liberty to the parties to agitate such matters in a civil suit. Now, in a civil suit, what happens is the gestation period is too long. Most of the time, civil suits take on an average 10 years. Now, 10 years is too much. Many a times, when the matters go to a civil court, the parties realize that if one party is going to be given some interim order where their development or redevelopment or their ownership rights get stuck, they try to resolve the issue. So most of the time, these matters which are relegated to a civil suit come to an end by way of a mutual understanding or filing of a consent terms where both arrive and come up with a mutual situation. I would like to share one more very important judgment, which is my own matter, which I have argued, where in Santa Cruz, there was an issue where a large plot of land owner was wanted to have his own bungalow right facing linking road, and he decided in 1982 to execute with a developer a lease agreement for the behind portion for formation of a new building. So the builder executed a lease deed in 1982 and directed the owner gave rights to the developer to go behind and construct a building. Accordingly, the building was constructed somewhere in 86. Society formed. After society formed, society was occupying peacefully, no issues about it. Society somewhere around 3 years back went for deemed conveyance. Now the problem which arose was, when the matter went for deemed conveyance before DDR, a situation arose where the society has a road, a small private road adjoining to the main plot where the owner has on linking road. That road is a private road. And that private road, society said, it is ours, we should be given rights on that private road. As whereas I was for the owner, I said the owner cannot be divested of that right. At the most, he can be only allowed right of passage. But that TDR and FSI rights and ownership rights cannot be divested to me. Such a matter was finally heard, and the DDR passed an order where he gave leasehold rights to the rear portion and continued ownership rights in favor of the owner on the linking road side. However, he made a mistake. The mistake which was made was the road which was required to be given to the owner, he gave ownership rights to the society behind. And that came to be challenged by way of a civil suit, and now it's pending before Honorable High Court. Luckily, we are now trying to resolve the matter where we are trying to have some meetings, and we are agreeable that this FSI issue will be resolved in the near future. But this is a very peculiar situation where sometimes the DDR make mistakes. Now, most of the time, the problems with the DDRs are they are not very qualified on the legal front. They come from the cooperative department, so they have limited knowledge, due to which they tend to make mistakes. And those mistakes are being repeatedly pointed out and shown before the Honorable High Court, and Honorable High Court keeps on rectifying those mistakes. Some of the DDRs use it as a precedent and ensure that these mistakes are not done again, but some of them keep on repeatedly doing the same. So Honorable High Court and its own wisdom has been repeatedly remanding and sending matters back with directions. You have made this mistake, rectify it and keep on doing it. So this is what I would like to share. Besides that, also, in the most easiest, I think, deemed conveyance, which I'm sure everyone must be knowing, is on a single plot. If it's a single plot, especially in smaller plots all over in suburbs, the easiest thing is to get a conveyance is to apply for deemed conveyance for the single plot, and normally in such circumstances, conveyance is granted if there are no complications such as a lease deed or something like that. Otherwise, when it comes to layout, as explained by the other previous speakers, including me, it should be conveyance, should be given only for the respective plots, the plinth area, etc., and the common RG and road should be given proportionate share as per circular of 2018. I think that would be sufficient for explaining the position. I have prepared a PowerPoint presentation and a note. For convenience, I've shared it with Mr. Isore on WhatsApp. I hope if you desire to have a look at all the judgments, they are all explained in my note, a 19-page note with all beautifully explained what are the do's and don'ts, what are the judgments and what are circumstances and situations which may arise from case to case, which I hope it can assist you, and I'm sure it will be shared by Mr. Isore. Thank you. Thank you.
Thank you, sir, for sharing your valuable legal inputs and perspective in the practical insights. And with respect to the assignment of leasehold rights and limits of jurisdictions, a well-explained point. And I would like to thank you for the note that you have prepared and shared with our president. And I'm sure that our president will share the note with all of us. Now we would move forward to our last presentation for today's evening. Senior Advocate Shri Sanjay Kadam. He's been associated with PIETA since quite a few years, and he is the go-to person in terms of any legal advice that PIETA requires. He has been a pioneer in many landmark judgments with respect to heritage, CRZ, premiums, RERA, LUC, and many other important cases. I would not take much time. Sir, please join us on stage, and huge round of applause for Shri Sanjay Kadam.
Thank you very much. Dear President, present President, past President, million committee members, executive committee members, and dear friends. Firstly, I received a call from Sukatme side saying that PIETA is having their function and the topic is dim conveyance. I couldn't believe my ear because the PIETA and dim conveyance, it is contradictory. Then I congratulate President because he is taking that topic which disturb his client. I won't be surprised that two of his clients may take away his brief thereafter, because he's trying to educate that particular section and sector of the people to whom that particular castles are built for them. So he's educating them through these particular things. So I really congratulate you by selecting this particular topic, and really the committee members who have supported to him. Prasad, very good done. I'm very happy for your this one. It's a good one. See, already all these particular speakers have given their particular various details about the dim conveyance concept. I don't want to dwell into that issue again. Basically, everything they have dealt with, I don't have to say. I just only deal with this word dim. Let's start with the basic. Deem. D-E-E-M. Deem. Deem, there is a legal fiction. Something which is in existence or not in existence, presumed to be in existence and presumed not to be in existence. That is what a deem. There is a presumption in the home that you are an earning member of the family, therefore you will be the owner of that particular money. It's a deeming fiction. Ultimately, owner of the money is somebody else. In fact, you become a debtor to that creditor. And sometime that particular creditor show you the door of your home, saying that you are not. Or they may say that today's lunch is not there, tomorrow dinner is not there, because you are not performed properly. So that is the effect of the deem. And if you put a ED, the ED word is very, you know in today's world what is the meaning of ED. So if you put ED, it becomes more empathetic. It means it is there. That's a qualification. And that ED came somewhere in 2018 in the amendment. Because government realized the legislation which they made in the MOFA is not being implemented in the manner by the people who were supposed to implement it. It's a noble and so-called social legislation. In fact, you cannot call it as a noble and social legislation in a democratic country, because you have got a right to also carry on your business, which is also the equally right. But government always like to do the business at the cost of you. They want to cherish that particular principle of so-called socialism at the cost of you. So therefore, what is the best way? Best way to make a legislation and make that legislation and make you to comply with that particular condition precedent, which otherwise you are putting your money to earn reasonable return there too. Now when we say that particular, and therefore they found that section 11 has to be emphasized there too. The promoter has been given obligation and he has to convey the things, and what he has to convey. See, there is a wording, he says that his right, title and interest, that is the three phases. Promoter, so deeming, when it comes to deem, what he has to convey, his right, if any, his interest, if any, if his claim, if any. But if he does not have anything, what he can convey? So deem conveyance come into effect provided promoter who possess that particular right, who possess that particular interest, who possess that particular claim, and still he refrain himself from conveying to the people, with the association of the people, for whom he is implementing that particular project. Therefore, even if you see, Honorable Court has time and again said that you can pass on the title provided you possess the title. That is the basic concept. As he said, the Pradeep has said, if the lease right, the promoter having a lease right, he can only pass on the further lease right, unexpired, residual period. Suppose he has got 99 years right, and 10 years he is exhausted. Remaining only 88, he can't convey the property in a common parlance. But this is one of the way to convey the property. The transfer of property says that there is various ways. If suppose I want to go to the church gate, I can go by the Western Railway, I can go to the Central Railway, I can go Harbour, I can go to the Coastal. So going to the church gate, there is a different path. So same way, getting that particular document in favor of the society, there is a different path. One is a conveyance, one is assignment, one is granted. In fact, the court has now come also on the ground of the even consent term executed between the parties. And that consent term executed between the parties, it has not converted into the consent decree. Now, in such a situation, the court says that whether the effect of this consent decree to be taken while conveying the property contrary to the consent decree, they say it's a very tricky question. It should not be totally brushed aside, but it can be looked into. That's what the court said, that it can be looked into. But any document which has been executed by the promoter after commencement and disclosure of his particular right into the property, and thereafter he executes some document contrary to that disclosure, then that execution of the subsequent document will not curtail the right of the promoters getting a conveyance of the property. In other words, to defeat the purpose of the deemed conveyance, if we create subsequent document and then say that that subsequent document I am supposed to give this area to ABC, the court will say sorry. Then you are defeating the deemed conveyance purpose. So therefore, if anything which has been disclosed prior to the implementing scheme, and that has been there on the record, even the court has said that it has to be in an operative part. It should not be in a recital part. So an operative part means a part which is binding upon the parties. There was one particular case whereby the right to way, which was been given, and right to way was given, then the society say that, sorry, we will not give this right of way. Why we should give the right of way to the bad person? The promoter say that I have agreed to give that right of way to the person who is the property behind me. Society says, no, it's a deemed conveyance. The registrar say that very well, nothing doing that right of way not. Court says sorry, because that right of way, it is a covenant provided into the earlier document. So therefore, the word court said that the promoter's right, title and interest, he has already had an acquisition of the right subject to that particular right of way, and therefore you are entitled. Even recent development which the court has taken into consideration, whether the various particular companies, various particular people, due to the various particular ventures, go into the NCLT. The NCLT is considered to be the safer haven. for the people, those who consider to be run away from the various particular misdeed they have done financially into their particular business. So that is a way. So one of the issue came before court, while granting the deemed conveyance, whether the NCLT permission is required, whether it is a mandatory, because now that particular corporate debtor is facing the music of the NCLT, and whether that IBC code will have the overriding effect on this particular deemed conveyance. Court says, sorry, it can't be. Though the matter has now traveled to the Supreme Court and Supreme Court has given the stay up to the 31st August or something like that. Correct me, Prasad? Then they say that very well, that can be later on. But this is a good directions, where the court say that any particular law which take away any particular circular, which take away your right, which has been given under this particular deemed conveyance, under this MOFA, then that event, that cannot be considered to be binding effect. Because IBC code is not meant for diluting the right which has been given by the statute to this particular group of organizations, and it can't be looked, it cannot be read down to that effect, whereby the effect of this particular deemed conveyance will be taken away. So court says that, sorry, it can't be, because the court has made a very, very nice distinction. They say that here, this society is not a debtor. Society is entitled to have the right. So there is not a derogation of the right. Here it is not something they are the debtor to this particular corporate creditor. They are not a debtor. It is their entitlement. And court has put a very nice quote saying that each sale, if there are 100 flats in a project, if there is 100 flat, with sale of each flat, the right of the promoter get diminished. It's like a marginal utility curve. The moment he sells 10 flats, 10% right goes down. If he sells 20 flats, then 20% goes down. It is a declining percentage right of the promoter in respect of that particular project he has taken in hand, whereby he is contractually and statutorily bound to convey that particular piece of land with the structure therein to the people for whom he has constructed and taken the money there too. Court has gone to the further extent saying that if there is a balance payment payable to the developer or to the owner, does not come in the way of the deemed conveyance to that extent. Dispute between the brother inter se of that owner does not come into the deemed conveyance. Dispute over the boundary does not come into that one. So they have said that even he may be having certain dispute with the financial institution will not come into the way. So many, because the law which has been made for your and my benefit. So therefore, every advent of this particular day, court infuse the life into that particular word to make a meaningful for a living you and me better in the society. And they look that particular deemed conveyance in that aspect. And now the 31st December 2025 is a shifting towards that directions. It is a good move, whereby and why this good move has come? Because they realize various difficulty in the implementation. As Pradeep said, that we, as a lawyer, we never go into 2,000 square feet or 5,000 square feet, sorry. We just only send our particular bill to that extent only. But that particular, we never go into that one because that is not our calculation, gross area of this area. हमको इतना मालूम है कि भैया TDS मत कट करो, क्या कट करो या GST लगो, बाकी का दे दो. So ये percentage wise मालूम नहीं. The fact is that it is shifting. The regime is now shifting. And the shifting is good because they say that in that event, you have to confine this one, and RERA and MOFA will go concurrently, simultaneously, and harmoniously. So nothing will prevail upon anybody. So you have to take, as Sukat Mehsar always say, Suvarna Madhya, and accordingly give it to that. If one is coming in the way, the other should be given aside. The guideline which has been given on the 22nd of June 2018, there was certain misconception in the mind of the people that guideline will prevail upon the law. Sorry. Guideline is guideline. Guide is guide. Guide cannot be master. Master is a master. What is master? That's just legislation. Guideline is supportive to the master. Guideline cannot be substitute to the master. It can't be supplement to the master. Any circular, any clarification, any corrigendum, any particular whatever government regulation also come, they are in support to make that legislation implementable, workable. Sometimes very invariably the government, BMC, formulate a SOP. SOP for the purpose of implementing what the legislature intend to. SOP cannot supplement that legislation. SOP cannot bypass this particular MRTP. Certainly not. So therefore, we have to give the meaning for that. And if the moment we give the meaning for that particular guidelines or any circular, we have to give in concurrence to that particular furtherance to achieving that object for which the legislature had made that legislation. So deemed conveyance is a good one, and definitely everybody has now got idea what the good deemed conveyance is of that, but it requires further deliberations. It cannot be with this particular short time, but I really congratulate the PIATA member. They did not put the topic like a deemed CC, each was. That would have been very interesting. Because I again asked the Sukhatme sir, are you sure it's a deemed CC or deemed conveyance? Well, no, it's a deemed conveyance. Well, it is something shocking because this is not your domain. So also no, the domain which is not belong to us, we want to go that. Well, then you now at the flag end of your life, you don't want to have your client at all. Because that's a way. So therefore, this is a good avenue you have done it. I am very happy. And the PIATA is like my homecoming again. No two way about. No two way about. I really anything. I really appreciate everybody coming here and hearing. In today's world, nobody comes together and also chat with each other because the son sitting in the next room, we have to text him, come on the dining table, there is a lunch. He will say, please bring that particular plate in my particular room. Sorry, I am on this scap and this one. But everybody is coming here and listening this particular speaker, and each and every speaker has given such a valuable input. Really, I also learned quite a lot thing into that one. Thank you very much for your presence.
Thank you, sir, for referring to the various court judgments and enlightening us and updating us with the relevant orders. And thank you for appreciating the step that PIATA has taken to divert from DCPR and take a new topic. So now I would like to call upon Shri Shirish Sukhatme for the overview of today's session. And from section 11 to MOFA to 2018 government guidelines, plinth areas, appurtenant areas, everybody has explained a lot. So now I would like Shirish Sukhatme sir to give an overview on the today's session.
Very good evening. It seems that you are deemed hungry now. And I will not consume more time. After such a Muluk Maidan Tof of Sanjay Kadam Saab, really I'll tell you, when program was happening and everybody was looking at me, Paune 6 वाजले Kadam Sahib kutet. And I called him and he didn't pick up. So I got deemed khadda in the port. If he doesn't come, like what will happen? Because we have to reach a climax somewhere, right? And that climax, I think he has given and he requires a great applause for that. After such a powerful explanation, we all have to agree that we have understood the deemed conveyance. We have no queries, right? Really, great talk, which is usually, and it's a common thing. Next is Pradeep Gandhi. He came up with such a large, he had sent me his note. I went through the note. After, I think, 2 paragraphs, I was just not understanding anything. And I said, like, ये कुछ किया होगा, इतना लिखा है, मतलब something must be there, right, in that. So ultimately, I just forwarded it to our president, and I forwarded it to Vishwanath to forward it to all, right? And you are free to get deemed confused about the whole thing. This session we were actually started when I was taking walk on Carter Road. I met Advocate Ramani, and he was walking, I think 80s he is. And I was knowing he has written book on conveyance, deemed conveyance, and that thick book. So I requested him, sir, you please come, and just because of we know you and you have handled this topic which is related to the property, right? Now always जुआ जोरू और जमीन, this is always a problem. It's सीधा है नहीं कुछ. So we talk of Jamin basically, and as we talk of FSI, we talk of conveyance, we talk of DCPR. We consider कि architect shall take this topic, but as he very rightly pointed out, well, they are in so much of possession. Like deemed conveyance means a lawyer's topic, right? Architect तुम कहाँ लेते हो यार? तुम plan बनाओ, plan pass करो, बिल्डिंग बनाओ, आरसीसी ये वो करो, डीम कन्वेंस में कहाँ ये गटर में आते हो तुम लोग? बट एवरीथिंग केम as Suyog very rightly pointed out, that when Kauravas said कि I will not give you the land which is on the सुईच्या आग्रावरचं लँड पण तुम्हाला मी देणार नाही. अर्थात आताचे प्लॉट तर सुईच्या आग्रावरचे असून त्याच्यावरती आपण सुई एवढ्या मोठमोठ्या बिल्डिंगी बनवून दाखवलेल्या आहेत. 5.4 FSI, 33(7) मध्ये तर 8 FSI, 9 FSI. म्हणजे ती जमीन तर सुईच्या आग्रावरची, जेव्हा आर्किटेक्ट त्यामध्ये करून दाखवतो, ती देणार नाही. त्याच्यामध्ये DDR कोण झाला? ते DDR म्हणजे कुरुक्षेत्र झालं, आणि त्याच्यावरती ते लढले. आणि आर्किटेक्टचं कायम काय होतं, तर आर्किटेक्ट धृतराष्ट्रासारखा डोळे बंद करून सर्टिफिकेट देत होता. काय संबंध नाही आमचा. FSI बघायचा, डिस्ट्रीब्युशन करून द्यायचं, 0 सर्टिफिकेट, 0 FSI लिहायचा, आणि बिल पाठवायचं, GST लावायचं, कॅश दिली तर ते पण नाही लावायचं. आर्किटेक्टचा संबंध एवढाच आहे डीम कन्व्हेन्सशी. आता ह्याच्यामध्ये पुढे जेव्हा सोसायट्या बनतात, आता ऑल द other speakers before these lawyers, they were just showing how architect is totally confused about the whole thing, because the property or the right is something which is basically conceptual. It cannot be graphicalized every time. You cannot graphicalize everything. For example, if one has 2 sons, one is fat son and one thin son, but they have equal share in the father's property. It doesn't mean. So ultimately share is something which is abstract. Share is something which is decided as a share in the property, right in the property. Whenever we want to distribute it or graphicalize it or show it on the plan, it is going to be totally difficult, because the first presentation which was done by Girkar Sahib, he was showing the layout of 11 buildings and RG distributed. There could have been, our architect could have designed everything with one building and large RG. Somebody would have entirely designed all row houses. So if the design changes, right or the property cannot change. That is the basic thing, right? So this is what entirely we started seeing right from the beginning. Our Girkar Sahib showed the plan. Then Satyen and other people, they were talking about MOFA and suddenly said that MOFA is now set aside now. RERA is going to decide everything, and it is going to be a federation now. This all information is very, very important to an architect because we are being asked to give certificate. In between, what we did was, as I'm taking review, I'm just telling you what has happened, right? In between, suddenly we showed you our municipal commissioner madam, right? DCPR was launched or released. New DCPR we launched. As per DCPR, what I say, what I think is, in DCPR, development तो builder चीज होती है. प्रमोशन तर बाजूलाच राहिलं. आता काय उरलंय तर फक्त CR उरलंय आता. बाकी काय उरलेलं नाही DCPR मध्ये. Everything is calculated in CR. And another thing is, one very important statement Commissioner Madam quoted in that, when we were talking about the AI, artificial intelligence is going to be injected in approval process. Assuming that natural intelligence of sub-engineer is now falling less, right? We want artificial intelligence now. Now that artificial intelligence, after it is injecting, I don't understand how the entire DCPR, auto DCPR will behave. Suddenly, if some injection has been given to you, sometimes patients go into that convulsion, right? So we are in the stage of convulsion now. We will not understand. But one, one very good statement she made, that statement was, she said, I want to bring artificial intelligence to such a level and to such a depth that building proposal department should not anymore become an attraction for engineers. This is a very important statement she made, that AI should come to such a level that ultimately building proposal डिपार्टमेंटला जाण्याची जी भाऊ गर्दी असते ती बंद झाली पाहिजे. या लेवलला मी आणणार. अँड वी रिक्वायर अ बिग अप्लॉज फॉर कमिशनर मॅडम टू हॅव at least courage to say that in front of such a huge mammoth engineering lobby. 42 पेजचा 4C रिपोर्ट बनतो. 42 पेज. आणि त्याच्यामध्ये श्रीराम जयराम कसं आपण म्हातारी माणसं लिहितात तशात पानात सेम असतं सगळं. ऑल 42 पेजेस आर सेम. अँड स्टील अप्रुव्हल्स आर ग्रांटेड. सो ॲटलीस्ट समवेअर AI also will get tired of reading this, ki architect says this, then sub-engineer says this, then assistant engineer says this, and then executive engineer says this. Are ka baba, why they are saying all this? Nobody says ki don't grant. They say grant. 9 people say the same thing for 42 pages, 4C report. And ultimately commissioner says, आता मी तरी काय करू? Okay. This is what is the process, so-called tedious process which is happening in DCPR. So, 6th edition has been launched now. There will be 60th editions also will be launched after some time, and Piata will also do it enthusiastically. Next time the book will come with somebody, weightlifters will bring the book. Ki 4 copies are here, 5 copies are still lying in the tempo. And remaining you read afterwards if you get the time. I don't know where this is going to end. I started my practice with thin, small DCPR book. Very simple, very clear-cut understanding. Then another 1991, little thicker one came. Now this DCPR which has come, and we have got another volume which is circulars. So circular is something means your brain should get circulated feeling. Because one circular says something, another circular again contradicts that. And which circular has to that sub-engineer decides. So this is all fun about DCPR, but we all enjoy it. मग अति झालं आणि हसू आलं. बट we could, like this deemed conveyance seminar also, Piata has conducted it successfully, that is what I feel. The topic which is not ours, we have touched it, and we have touched by taking help of architects, engineers, and two very eminent lawyers whose speech was culminating speech. And ultimately, after their speech, I came to know that this is purely a legal subject based on architect certificate if required. If not required, still without architect certificate, the shares in the property can be decided. Thank you very much.
Thank you, sir, for the overview. I can see everybody have a light movement after the exhaustive presentations by all the speakers. So now we move forward to the most interactive session for the today's program, the panel discussion. And we have heard the individual perspectives from technical planning and legal point of view. Now the panel discussion will give us an opportunity to bring these perspectives together and examine the practical challenges that are faced by professionals and the societies. The session will be moderated by our President, Shri Sandeep Isore, and I would like to call upon stage Shri Sanjay Kadam, Shri Pradeep Gandhi, Shri Prasad Satyan, Shri Yomesh Rao, Shri Shoyog Sheth, and Shri Abhiraj Girkar ji to be on the panel, please.
We have experienced a very knowledgeable session with an injected entertainment in between. Thank you, sir. Thank you for the lighter vein dose in between. But considering that is what I was discussing with IPP, Dubal sir, or our prominent speakers, considering this as a almost 9. So rather than making it as a panel discussion, let it be a question answer session. That is what I feel, so that those who will be having certain aspects in mind after listening to so many speakers, they will not remain unanswered. And only panel is discussing without any interaction with those who are listening to us for last 2 hours, more than 2 hours. बरोबर sir? मला असं वाटतं. Yes, sir? It's a good idea. So, Vishwanath, I would request you to circulate the mic, and let us start with first question. Yes, please.
Hello.
Please.
Good evening. My simple question, after the guidelines or circular of December 2025 coming in force, will the convenience for layouts given only after the OC of the last building in the layout?
Yeah. After the RERA, I mean, after 31st December 2025, the conveyance, the deemed conveyance or the deemed conveyance will be given only after the last building or the last wing of the layout is completed, OC is received, then only it will happen. And parallelly, the FX body has to be formed within 3 months, and the conveyance has to be, you have to obtain the conveyance within 3 months. Both things will come parallelly.
Any further input on that subject? Say.
Hello. But sir, one thing, but recently judgments have been given that even though it is incomplete, conveyance can be given.
See,
Recent judgments, sir.
Yeah, there are. They are basically relied on the foundation on the basis of MOFA only, without taking into cognizance of the 31st December. But having said so, see, there is a two concept. India recognized two concept in ownership, which like is a dual ownership. You will find in a various particular suburban area, there is a Imla Malik. So there is a conveyance of a structure and the conveyance of the land or the maybe a lease of a land. Normally, MHADA layout plan, whenever they execute a lease a land beneath to the structure and they execute a conveyance for a structure. So you become a owner of a structure and you become a lessee of the land. So dual ownership is permitted. So therefore, even if that particular conveyance of the land will be executed after that particular last building is concerned, it does not preclude for executing a conveyance of a structure.
Hello. To give clarity, one more clarity, we come across many a time situations where in 1990s buildings are made, remain incomplete, builders for whatever financial constraints or whatever, incomplete. And some buildings are made, some are incomplete, large layout. In such a situation, you cannot expect that conveyance has to be waited till OC is granted, maybe after 30 years. So in such a situation, the matter which Justice Marne has just passed an order a few days back, the situation is absolutely right, where the builder was required to complete the building, but for whatever reason he could not complete. In such a situation, conveyance should be granted because that is a rightful duty of the promoter to grant conveyance and the obligation of the promoter to give conveyance, and the duty is cast upon the builder to give conveyance which he has failed to give. Because under law, under section 11, within 4 months of formation of society, he is required to do it, even if it's a large layout. If some portions remain incomplete and he has not made a mention of it, why should the other flat purchasers suffer? So therefore, this matter, depending on facts of circumstances, Justice Marne's order was rightly said.
Can I? There are so many answers for one question. Anyway, my question is...
Is there a requirement of deemed conveyance that it should be allowed only after granting a OC to the building?
In fact, the court has said that OC is not a condition precedent because OC is supposed to be obtained by whom? By the promoter. He failed in his duty. It is his obligation. So he cannot defer that particular your entitlement because of his own fault. And you cannot have a premium on your own mistake. So therefore, the court says that not bringing the OC, not giving the payment, not doing this one, anything cannot come in the way of granting a deemed conveyance.
Also to add one more point, many a times we come across situations where builders are giving soft possession. Now soft possession is actually not possession because it's without an OC. He permits you to go inside and do interiors, etc. But under the guise of interiors, most of the flat purchasers are extending those, these, understand, windows and dry areas, certain portions which are required to be kept open are still covered. Now in such a situation, it's whose fault? It's the flat purchaser's fault. It's not the builder's fault. Due to which builder is unable to give OC. And the burden is under law to be given by OC by the builder. But builder can't be put into this situation because it's not his fault. And there are very conflicting judgments. Consumer courts are saying grant OC in favor of flat purchasers because it's a Consumer Protection Act has been framed for the consumer. And definition of the word consumer means flat purchaser is a consumer. But due to these difficulties, whenever an order is passed by the consumer court for grant of an OC, builder puts his hands up and says, sorry, I cannot grant you because you have done illegal work. I have not done something illegal. I would have given you OC, but because of your fault, I can't do it. So again, you are in a dilemma, in a very catch-22 situation, who is right, who is wrong. And in the end, this fight keeps on going on and on, then some solution comes where both parties meet and resolve the matter.
Another question is, this is may not be related to a legal. Now today what we heard a lot about the legal aspect and how to get the deemed conveyance. This is the process till obtaining the conveyance. Now we all are the concerned with the process required after obtaining the conveyance and when the proposal is submitted for redevelopment. So this is a technical issue, not related to this. In many cases, it happens. Suppose there are so many buildings in the layout, and one or few buildings get the dim CC, and on that basis, they submit the proposal for approval. Then how to process that proposal for approval without a layout? Or is the layout is required to be approved based upon the dim conveyance so as to assign or get the demarcated the plot area for that particular building? This is a technical question. The technical, any person may, Suyog may answer that.
On the legal angle, I just explained to you. So if such a matter, if deemed conveyance is granted for a small subplot of the large layout, he will be given, his plans are going to be passed as per the deemed conveyance granted to him for that subplot. Now, when that deemed conveyance is granted for that subplot, it will be the plinth area as explained in the presentation.
That's very easy example. I am asking about the complicated example, complex situation where there is a plot area for that particular building. In addition to that, there is that share of undivided share of the layout roads or layout RGs or other common amenities. In that case, it's very complicated and it's very difficult to approve the plans or submit the plans for redevelopment.
May I? So what you say is correct. When a proposal, first thing is, if we read the complete 2018 guidelines, it's very clear that it's not only that the deemed conveyance is in order. After the deemed conveyance, even the registration has to happen, and after the registration, property card mutation also has to happen. So this is a complete process. Deemed conveyance, if just getting an order is not sufficient, the order has to, one has to follow it with registration and then mutation entry in the property card. So mutation entry in the property card, plus when the registrar passes an order, in most of the cases, they pass a sort of a map of your area in the larger plot. Even that is passed. It's not only just a notional that you get 500 area or 700 square meter area. They come out with the map, number one. Number two is, as you rightly pointed out, for the common amenities like share in the road or share in the RG, RG cannot be subdivided. So for that, a layout and concurrence from the rest of the people has to be there. But I believe if they don't concur to give share of that FSI share of that layout RG to that particular person, it would amount to contempt of court because he's a quasi-judicial order. The competent authority passing an order is a quasi-judicial officer. So that would amount to contempt of court. That is my opinion, my understanding of the law. Lawyers may clarify.
I have a subsequent question to that. Whether on the basis of this deemed conveyance, can plot be subdivided? That answers your granting a permission of building. If it is subdivided, then only you can get a permission.
Can I answer? Hello. Your point is right, but see that you can't subdivide. This is all the notional subdivision. For subdivision of the land, that plot should be with the FSI. And that in the layout, it is not possible. So the ultimate solution for that is the notional subdivision. So that's what I was telling you, that land should be divided as per the plinth area and apparent land, so that at least that land they will get. And then they will get the share in the RG and the open roads. So ultimately what happened, after 50 years, all building will not come for redevelopment. Some building will come for redevelopment. And then if we give the whole share of the land, then all buildings has to depend one upon each others. So if we give at least certain lands to them and a share in the RG and road, so at least they can do their redevelopment.
Shashi, I will address that question. See, understand, when the government came up with a law, which is MOFA, and subsequent guidelines, there was some intent of the government. By going for very narrow interpretation that physical subdivision, separate property card, separate CTS plan, if we do all that and insist on all that, that means we are trying to defeat the purpose of the government. So we'll have to, so issue is, it's not that computers are granting approvals. Finally, why the humans are granting approvals? At BMC, I believe that we'll have to craft solutions. It's not a clear-cut solution. We'll have to craft a solution to address the situation that now so many societies are coming with deemed conveyance. How to give effect to the intent of the government and legislature, we'll have to craft specific solutions. Probably BMC might also have to come out with SOPs if required. If you cannot have a different solution for different society. So probably a SOP may have to be crafted by the BMC. That I think will solve the problem.
I think part of my question's answer is already given by you. But what I mean is, number of concessions are given in the open spaces. And what is the open space which you are supposed to leave for the apparent open space? That is a big question. Because the FSI concessional things are there, where the open spaces are not in proportion to your requisite regulation. Even in regulation, concessions and condonations are required to be given. In that event, when you carve out a plot, it will not be giving proportionate FSI of that plot. And at time, when one has to go in for redevelopment, these issues will be very difficult. So that is one question. And for Kadam sir, I wanted to ask, it is a deemed conveyance deficit. And like Pradeep Bhai had rightly said, your leasehold rights, you cannot convey. How does the leasehold rights property gets deemed conveyance?
On the legal angle, very simple, assignment of lease. You can't have conveyance. It will be only leasehold rights for that portion of which has been given on lease as per the agreement. And a party can go in, the society who gets that assignment of lease can go to the BMC and apply for development, and the permissions will be granted. And in my view, I'm sorry, but there is no precedent to that effect which I have not come across. We don't require permission of lessor in such a situation. Otherwise, what happens is every time lessor's permission is required because he is the owner of the plot of land, his name is there in the PR card, he is the principal, he is the owner under Transfer of Property Act, supremest right. Sorry, I don't agree. Because so many such instances keep on coming across where I have come across so many matters where leasehold rights madhe aramat we can just go and apply and they grant. But yes, there is no law up till now. I have not come across anything.
It will be deemed assignment. Is that provision
assignment?
covered
Yes,
under
yes.
this?
Deem assignment of lease.
No, whether this provision is covered under this particular deemed conveyance.
Yes, yes, yes.
Yeah.
It is deemed assignment of lease. DDR, I have come across so many. My own example, my own matters I have come across. Deemed assignment of lease, not deemed ownership.
Answer other part of Vertice's question. Sir, the question of dividing the plot with plinth and appurtenant area will not arise in cases where there is open space deficiency. Because if you go by the logic of dividing the plot in proportion to the built-up area share of individual building, then automatically the plot will get conveyed with deficient open spaces for both the plots. See, this basic concept of plinth and appurtenant area will come up mainly when one FSI kind of societies or 1.33 zonal FSI kind of societies, when TDR and all that was not there. Because ample open spaces were there. See, just to give a corollary, in MHADA layouts, when there are two societies which are adjacent to each other and a plot is to be conveyed, there's a MHADA resolution which states that the land has to be divided equally. You draw a line which is equal to both the plots. So if the joint open space is 12 meters, you provide a line which is at 6 meters for both the societies, provided height of both the buildings is same. It is a MHADA resolution. So we can draw a corollary here and derive a subdivision. But in cases where open space deficiency has been taken because the FSI was high, such a case, this corollary of plinth and appurtenant open space may not arise.
There the protected FSI concept will have to be incorporated in deemed conveyance. Otherwise, it will be a great problem for the future redevelopment.
So, in furtherance to this one, if there is a lessor and lessee relations, there is now the judgment which has come the Bombay High Court, which is now challenging the Supreme Court about the Adarsh Nagar Worli, whereby the MHADA at one particular day realize that this particular land belongs to me, irrespective of the 50 years, 60 years of the lease deed executed in favor of the society, and the society has erected their particular 53 or 58 societies are there. MHADA came with their particular novel idea to how to, it is a cluster development, DNDA. And that the Honorable High Court has upheld that particular thing. That is giving a very beautiful word saying that is a larger public interest, welfare flame, bala, 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 bala. Fine. But they have forgotten fundamentally one point, which the Supreme Court, now the issue is there and the matter will be on the 16th, I think 31st. Lessor and lessee relation emanate from the Transfer of Property Act. Transfer of Property Act is a central act falling into the List 1. List 1 is a prerogative of the Parliament. List 2 is a prerogative of a state. The laws made by the Parliament which encompass List 1 cannot be diluted by the state legislature who are having a competency only in List 2. Now, if the Transfer of Property Act, Section 105 to Section 111, deal with the right of the lessor, deal with the right of the lessees, deal with the obligation of the lessees, deal with the obligation of the lessor, where does the right get to the state government to read down that particular section which has been formulated by central government? It's a big question mark. Therefore, the MHADA taking away the right of this particular societies in an executive facade, according to me, seems to be very difficult to get sanctity from the Supreme Court, though the matter is pending there too. Therefore, your answer for your query, if the lessee want to do something for the land which has been leased out by the lessor, knowing fully well that I want to continue as the owner of the property, therefore I am giving on rent or this demise premises with the lease rent subject to you complying this A, B, C, D condition. The moment you breach that condition, I got a right to re-entry, right to take back the possession, because I have not divested my right as a ownership with you. You are a step below to me. So in the event, if anybody try to take away the right by virtue of this executive facade, then even a section 11 of the MOFA, we say that promoter's right, promoter's interest, if any. So here, if any, means a lazy, as he said that assignment, subject to the terms, you cannot bypass him. How it could be? Impermissible law. Otherwise, see, it will today what happened, there is a legislature is competent to make the law for the local needs of their particular state. So therefore MRTP, therefore BMC, therefore MHADA, therefore slum, therefore the local legislature, Mamletdar Code, this one. So this is a need of the state of Maharashtra. Sometimes it is a need of the local, this particular city of Mumbai, therefore DCPR. The DCPR that I think Ishore sir will say something which is extraordinary. It is the first time in DCPR it has come excluded portion bulky than the included portion. I don't know, this is unique in the entire world, but it has happened. And that excluded portion slowly, gradually started diminishing the moment you approach to the UD department with your particular satisfactions of the certain queries. So that's a different aspect altogether. But it still remains. So local needs need is aware by the local legislation. So local legislation cannot hijack by the virtue of this one. So therefore, the lessor rights still continue to abide. That is my submission.
Yes.
Bola, bola.
Sir, sir, as
Sir,
per
you have said the-
Barnes judgment, I think the provision of RERA is going away indirectly.
See, it will not be applied. Firstly, people have got something misconception in the mind, RERA is something. RERA is a regulatory regime. Please keep in mind. RERA does not give me right. RERA is a regulatory regime to regulate the real estate business between the developer, promoter, and estate agent and allottee. Nothing more, nothing less. They have to only regulate. Regulatory regime cannot take away my fundamental right or statutory right. It's only regulatory. For example, if there is any particular security, if I hire for the purpose of protecting my particular building, the security cannot become owner of the property. The security cannot say to me not to come at this time, that time. You are being appointed by me. So REGA is a regulatory regime. The regulatory regime cannot bypass or cannot infringe my particular right, which has been given by the statute, which is a valid statutory right. So that can't be.
Sir, by giving the others example, I think you have hit the nail.
So, one last question, please.
Sir, very clear. Yashwant, simple hai. No, yes, see, understand. If say deputy registrar just passes a written order, okay, without any annexures, suppose if that happens, would anybody understand that order? Because that order pertains to a plot of land and division of plot of land. If he just passes towards north CTS number so and so, towards south CTS number so and so, remaining two, because this plot is going to be part of a larger CTS. So he has to draw a sort of a sketch, number one. Number two is, he has to also say various rights. So whatever is required to clarify the judgment passed, the order passed, has to be added up. Otherwise, that order will not make any sense. There is a small request that specific questions can be brought to the professionals' offices so that they can also earn some revenue.
आता मी बोललो तर चालेल का? सर्वांची परवानगी घेतो. सर्वप्रथम फार अतिशय उत्कृष्ट, म्हणजे जे आमचे डाऊट्स होते ना भरपूर क्लिअर झाले, पण तरीसुद्धा एक शंका राहिली आहे. मला फक्त एक स्पष्टीकरण हवं आहे, क्लॅरिफिकेशन पाहिजे. लीजचं आपलं जे आहे त्याच्या बाबतीत नाही म्हणत. फ्री होल्ड जर समजा एखादी जमीन आहे, 15-20 हजार स्क्वेअर मीटरचा लँड आहे, त्यात 5-10 बिल्डिंग्ज आहेत. आता आपण फिगरवर नको जायला, एक फक्त कन्सेप्ट समजूया. 8-10 बिल्डिंग्ज आहेत, ग्रामपंचायत, नगर परिषद, नगरपालिका, महानगरपालिका, FSI 0.5, 0.75, 0.85, 1. मी फक्त बेस FSIचं बोलतो आहे. आता पूर्वी जेव्हा एखादा लेआउट सुरू झालेला आहे, 0.5ने सुरू झाला, नंतर 0.75ने दुसरी बिल्डिंग झाली. विकासक एकच आहे, मालक एकच आहे, तिसरी इमारत त्यांनी सुरू केली, चौथी केली, आणि काही 40% लँड त्याचं समजा त्याचा वेकंट आहे. आणि आता त्याला त्या 40% इमारतीवर आजच्या DCP 34च्या हिशोबाने त्याला इमारत बांधायची आहे. आता तर TDR वगैरे सगळं आलेलंच आहे. पूर्वी TDR नव्हता समजा, काही वेळेस इन बिटवीन TDR आला असेल. माझं एवढं म्हणायचं आहे, जर सुरुवात झाल्यापासून एखादी इमारत सुद्धा 0.75 FSI असेल आणि त्यावेळेस 4 इमारती बांधून झाल्या असतील, 500-500-510, तर त्यांना इन प्रपोर्शन तेवढी जमीन मिळायला हवी असं मला वाटतं आहे. रोड्स आहेत, इंटरनल रोड्स आहेत, RG वगैरे, ते सगळे प्रपोर्शनेट आहेत. त्या लेआउटमध्ये समजा 4-5 मिळकत पत्रिका म्हणजे प्रॉपर्टी रजिस्टर्ड कार्ड आहेत. माझं असं म्हणणं आहे, म्हणजे एक फक्त क्लिअरिफिकेशन पाहिजे की डीम कन्व्हेन्सचा क्षेत्र नक्की करताना टू फायनलाइज द डीम कन्व्हेन्स एरिया, हे सगळे एरिया अंडर रोड, एरिया अंडर RG, PG वगैरे सगळे कन्सिडर केले.
पूर्ण लेआउट आहे, आपल्या डोळ्यासमोर आहे पूर्ण लेआउट, तर त्याचा त्यावेळेसचा जो बेस FSI असेल, तो बेस FSI विचाराधीन घेऊन पूर्वी 0.5 असेल, 0.75 असेल, आणि जो काय बिल्टअप एरिया त्यांनी आता जसं आपण सर्वांनी सांगितलं की रो हाऊसेस आहेत, टॉवर आहे. आता टॉवर करता TDR आल्यानंतर त्यांनी TDR पर लोड करून वगैरे 40-50 माळ्याचा टॉवर बांधला असेल समजा, किंवा 20 माळ्याचा. माझं असं म्हणणं आहे की 4-5 मिळकत पत्रिका आहेत, एक लेआउट आहे, ह्या प्रत्येक सोसायटीला त्यांच्या बेस FSIच्या हिशोबाने त्यांचा प्लॉट एरिया किती येतो तो, शिवाय प्रपोर्शनेट एरिया विच इज इंटरनल, म्हणजे त्या लेआउटचा इथे RG वगैरे असा मिळून त्यांच्या प्रॉपर्टी कार्डामध्ये त्या पर्टिक्युलर सोसायटीचं क्षेत्र नमूद केलं तर असं होऊ शकतं का? कारण काही ठिकाणी रो हाऊसेस आहे, त्यांच्याकडे जमीन भरपूर आहे, टॉवर आहे, त्याच्याकडे जमीन कमी आहे, त्यांनी FSI वापरून झालं, त्याला काही फरक नाही पडतो. पण बाकीच्यांना तेवढा प्रपोर्शन, जसं तुम्ही सांगितलं 1.7% वगैरे, असं म्हणजे बेस FSIचा एक हे धरून, बेस धरून प्रपोर्शनेट डिस्ट्रीब्युशन त्याच्या प्रॉपर्टी कार्डामध्ये ती नोंद होऊ शकते का? हाच माझा प्रश्न आहे. प्रायव्हेट लँड. थँक्यू सर, सॉरी जास्त बोललो होतं.
एक्झॅक्टली आता तारीख आठवत नाही. 2008चा सरकारचा एक GR आहे, महाराष्ट्र सरकारचा एक GR आहे, 23 नोव्हेंबर 2007 करेक्ट. तर त्या GR मध्ये स्पेसिफिक मेन्शन केलेलं आहे. तुम्ही जे म्हणता ती सिच्युएशन आहे की बऱ्याच बिल्डिंग झालेल्या आहेत, एक प्लॉट रिकामा आहे, मी मालक अजूनही आहे, मी कन्व्हेन्स दिलेलं नाही, मला त्या उरलेल्या प्लॉटवर बिल्डिंग बांधायची आहे, तर पूर्ण लेआउटचा मी TDR घेऊ शकतो का, हा प्रश्न आहे. त्या प्रश्नाला गव्हर्नमेंटचा डायरेक्टिव्ह आहे लोकल प्लॅनिंग अथॉरिटीला की तुम्ही TDR देताना त्या ज्या बिल्डिंग बांधल्या गेलेल्या आहेत त्या जेव्हा बांधल्या त्यावेळेच्या रेग्युलेशनप्रमाणे त्यांचा प्लॉट एरिया किती आहे ते धरून, जर उर्वरित प्लॉट एरिया असेल तर त्या उर्वरित प्लॉटचा आणि त्या प्लॉटचा TDR एवढाच देण्यात यावा, असं 2007चा ज्यांनी तारीख एक्झॅक्ट सांगितली गव्हर्नमेंटचा GR आहे, आणि तो GR आजही बाइंडिंग आहे. त्यामुळे आपण जे म्हणताय ते सरकारने आधीच विचार केलेला आहे आणि त्याप्रमाणे सरकारने तसे निर्देश लोकल प्लॅनिंग अथॉरिटीजना दिलेले आहेत. मग ते ग्रामपंचायत असेल, नगरपालिका असेल, महानगरपालिका असेल, जे काय असेल त्यांना हे निर्देश महाराष्ट्र सरकारचे असल्यामुळे पूर्ण महाराष्ट्रभर लागू आहे.
म्हणजे थोडक्यात विकासक अस्तित्वातल्या सोसायटींचा TDRचा हक्क हिरावून घेऊ शकत नाही.
23 नोव्हेंबर 2007ला महाराष्ट्र सरकारने पूर्ण महाराष्ट्रासाठी हे नोटिफिकेशन आणले की ज्या माणसाचं जे FSI, वॉट एव्हर FSI वॉज कन्झ्युम्ड, द फ्युचर FSI ऑफ द सोसायटी, वेदर कन्वेड ऑर नॉट कन्वेड, वॉट एव्हर इज द फ्युचर FSI ऑफ दॅट पर्टिक्युलर इज नॉट एंटायटल्ड टू बी टेकन अवे बाय एनी वे. दिस इज अ व्हेरी सिम्पल. त्या तारखेनंतर मला तरी वाटतं की कुठल्याही कॉर्पोरेशन, ॲटलिस्ट कॉर्पोरेशननी तरी नाही केलं असावं. ह्याच्या आधी जे झालं आहे त्याच्यासाठी आमच्याकडे वकील आहेत, कारण ते मॅटर्स थोडे कॉम्प्लिकेट होऊन जातात, कारण इट वॉज नॉट अ GR अँड पीपल हॅव डन सर्टन थिंग्स अँड इट हॅज हॅपन्ड. सो सच केसेस विल बी बेटर डेल्ट बाय द लीगल फॉरम.
बरोबर सर, थँक्यू व्हेरी मच.
आज उमेश जो बोलला ना तो बरोबर आहे. आणखीन इनफॅक्ट कोर्टाने बऱ्याच वेळेला निर्णय देताना सांगितलेला आहे. इनफॅक्ट आता गेल्या आठवड्यामध्ये पण जजमेंट झाली, त्याच्यामध्ये कोर्टाने असं सांगितलं की सोसायटी स्थापन केल्यानंतर 4 महिन्याच्या आतमध्ये तुम्हाला कन्व्हिन्स करायचं असं कायदा नमूद करतो. पण तर कोर्ट काय म्हणालं, कोर्ट म्हणालं की असं जरुरी नाही की त्यांनी 4 महिन्यामध्ये करेलच तो. त्यामुळे ज्या वेळेला ती सोसायटी स्थापन करण्याची परिस्थिती उद्भवली होती परंतु त्यांनी ती स्थापन केली नाही, त्या दिवसापासूनचा FSI त्याला.
बरोबर. पण म्हणजे मिळकत पत्रिकेवर प्रपोर्शनेटली सगळा एरिया क्षेत्र नमूद होऊ शकतं, बरोबर ना?
That circular says for TDR and future FSI. Today it can be extrapolated to any future FSI under any regulation which is subsequently brought into force.
फार सुंदर समाधान केलं आपण. थँक्यू व्हेरी मच.
One last question by me. Before 1991, the layout road FSI was not given to any buildings in the layout. Now those buildings are coming for deemed conveyance. So whether they can ask for the proportionate FSI of that new layout road when now the FSI is allowed, because the conveyance should have been given at that time. So whether they can ask today.
तुमची काय इच्छा आहे?
आय थिंक त्या काळी पण लेआउट तुम्ही लेआउट रोड वॉज अज्युम टू बी टेकन इन केसेस वेअर लेआउट आणि आरजी आणि लेआउट रोड प्रिसाइसली 67 मध्ये लेआउट रोड आरजी दोन्ही डिडक्ट व्हायच्या. 91 मध्ये लेआउट रोड आल्यात आणि आता आरजी पण आली. नाही, इट इज व्हेरी क्लिअर दॅट एव्हरीबडी इन द लेआउट हॅज द प्रोपोर्शनेट राईट ऑन द प्रायव्हेट layout road as well as the RG which has been shown in the slides. So it is a clear. Only thing is that सरकार ते रोड आता BMC रोड झाला आणि तुम्हाला TDR पाहिजे असेल तर सगळ्या 16-18 सोसायटीचे सगळ्यांची सह्या घेऊन या, नाहीतर त्याचं बेनिफिट देणार.
आता मला पण भूक लागली आहे.
So any further queries to then you can come to the office at any time.
Yes,
no
yes.
issue with the docket. I will give it to you. Thank you.
शेवटचा कार्यक्रम आय विल रिक्वेस्ट अक्षत टू थँक एव्हरीबडी.
Yes. So now I would like to conclude today's workshop. It was a very long and exhaustive one. And on behalf of PIATA, I would like to express my gratitude to all our distinguished speakers, Advocate Shri Sanjay Kadamji, Shri Pradeep Gandhi, Shri Prasad Satyan, and all other speakers and dignitaries. Today's program has given us an opportunity to look at deemed conveyance from multiple perspectives: statutory, legal, planning, technical, and practical. Most importantly, today's deliberations remind us that effective professional practice requires us to understand not only the regulations themselves, but their technical applications and legal interpretations. Thank you, PIATA, for organizing this seminar. And now I would request everybody to join us for dinner, please. Thank you.